Thank you, sir.
Okay, no problem. All right, so the date, very first thing that we see, of course, that has changed. The date on it is May 4th, 2026. And of course, we know that really didn't come out until June. And we only had until July the 1st before this became mandatory. Most of the time, they give us a little bit of transition time, maybe 30, 60, maybe up to 90 days. This time, that didn't happen. We didn't get much of a transition time at all, about a month at best for some of these forms. Some of these forms didn't even come out until the 15th. So we really only had a couple of weeks. So we were having to kind of do this on the run for a lot of us, but I think we'll get it down anyway. So we'll kind of take it provision by provision. First provision where we talk about the parties, not really any changes here. Buyer and seller, all that information is the same. We don't really see any changes taking place until we get into section 2, which talks about property. And I have one word highlighted that they have added in under improvements, and that is generators. Now, generators, of course, they're talking about the ones that are permanently attached, because if you go far enough up, you'll see that they have said permanently installed or built-in items. So this would not necessarily apply to maybe portable generators if somebody has maybe some gasoline powered thing that they might have that they can crank up and run their refrigerator or freezer or something like that off of. They're talking about permanently installed that are connected probably to natural gas and of course attached to the electrical system, because that's the whole purpose of the generator, is to keep parts of the house working electrically when the power goes out. So generators is not included in the unimproved property contract. It's also not included in the new home contracts, but for totally different reasons. Not included in the unimproved property contract because it's unimproved. So there's not going to be anything there. So we don't have to worry about the possibility of does this generator stay or not, because it's not going to be there. In a new home scenario, if you are able to use the new home contract, whether it be completed or incomplete construction, they also don't add in the word generators, because if you look at those contract forms, they just say all improvements. So it's already included in there. They don't actually go and name them individually in the new home contract. It's just understood that since nobody's ever lived there before, that all the improvements or accessories that are on that property are going to be included in the sale. So not there unimproved property, not there on new home contracts. You will find it in every other type of contract form we've got. Rest of section 2, looking at accessories, exclusions, reservations, all that is still the same. And in fact, really the rest of page 1 is all the same. Sales price information is there. The information regarding financing is there. Getting into section 4, looking at leases, all of that information also still there. No changes regarding the types of leases, that if those apply to this particular transaction that you're working on, then there will be an addendum that will need to be attached to the contract. If it's a residential lease, then the addendum is called the addendum regarding residential leases. If it is a fixture lease, then it is an addendum called the addendum regarding fixture leases. And if it is natural resource leases, then the addendum would have to do with natural resources. So no other changes to page 1. Down at the bottom of that page, I have highlighted the form number again. The newest form from the Real Estate Commission standpoint is 20-19. From your Texas Association of Realtors, it is still TXR 1601. All right, so we'll move on to page 2. Page 2 of the contract, starting with section 5, earnest money and termination option. The only real change besides the one that I've highlighted is that they had certain words that they used to capitalize, and they decided that they didn't need to do that anymore. Earnest money and option fee, those words used to be capitalized for whatever reason. They feel like that's not necessary anymore, so they have taken that out. So of course we know that earnest money and option fee has to be delivered to the title company within 3 days after the effective date of the contract. Now, there is an exceptions to that. If day number 3, when we count every single day, the day the contract is signed does not count. We don't start counting until the next day. So the next day is day 1. So whatever day that is, day 1, day 2, day 3. If day 3 should happen to fall on a Saturday, Sunday, or legal holiday, then we know that there is an automatic extension granted to the next day that is not a Saturday, Sunday, or legal holiday. There has been some confusion as to what is considered to be a legal holiday. So they clarified that in this section of this newest version of the contract. In this section, they have added in where you would go to find out what a legal holiday or what they consider to be a legal holiday. So like it says, it means a legal holiday described in section 662.003, 662.003B, A and B, numbers 4 and 6 of the Texas Government Code. So I'm going to see if I can switch screens here real quick. And I did record the actual date so you can see what they are. So let me see if I can get to that here and share that with you. So this is another form that we're going to look at when we finish here. And let's see. Right there. There we go. All right. So these are the dates that are considered legal holiday and according to the Texas Government Code. So New Year's Day, which of course is January the 1st, Martin Luther King Jr. Day, which is the third Monday in January, President's Day, which is the third Monday in February, Memorial Day, which is the last Monday in May, Emancipation Day, June 19th, Independence Day, July the 4th, Labor Day, the first Monday in September, Veterans Day, November 11th, Thanksgiving Day, and the Friday after Thanksgiving Day, which of course is the fourth Thursday and Friday in November. And then the last one is Christmas Day, December 25th. So if you notice, it does not include Christmas Eve, does not include New Year's Eve. New Year's Day is included, but those 2 days, Christmas Eve and New Year's Eve, are not included. So those are your legal holidays according to the Texas Government Code. So you can find it. You can find it just about anywhere. I went and pulled it up to get that information to be able to share that with you. So there that is. All right, let's go back to our contract form. There. All right. So the rest of that section, section 5A, remains the same. 5B, termination option, that information also remains the same, not really any changes there. And in fact, really for the rest of section 5, no real changes. So we have the termination option, all of that information remains the same. Section letter C, failure to timely deliver earnest money, failure to timely deliver option fee. Now, there are no changes here, but I thought maybe we would take just a second and go over the information regarding what happens if, because I know there's a lot of confusion sometimes about these two things, that if the money does not get delivered, what happens? I know that we've had instances where people thought that it automatically kills the deal. Well, no, it doesn't. And so I thought maybe we'd just take a second and go ahead and look at it anyway. So Section C talks about failure to timely deliver the earnest money. If the buyer does not deliver the earnest money to the title company within the time allowed, which of course those 3 days after the effective date of the contract, then now it opens the door for the seller to terminate the contract. There's no automatic termination here. The buyer does not get the right to terminate if they don't deliver the money. The buyer's in the wrong. The buyer's in breach of contract. They have not delivered the money like they were supposed to. That opens the door to allow the seller to terminate the deal if they want to. They don't have to. Seller could say, that's okay. They didn't deliver the money like I wanted them to, like they are supposed to, but I'm good. Let's go ahead and continue on. It's entirely up to the seller. Now, it also says there's a little bit of grace here that if the buyer gets the money there late, if they get the money to the title company late, and by the time the money gets there, the seller has not exercised their option to terminate, then the deal goes on. We're good. So there's a little bit of grace extended to the buyer there. D talks about option fee. If the buyer does not deliver the option fee, it definitely does not kill the deal. As a matter of fact, what it does is it actually solidifies the deal that much more. If the buyer does not deliver the option fee within the time allowed, now the buyer is locked in as the seller to the transaction. Transaction's moving on. Buyer has now lost the opportunity to terminate based on the option period. If they have not paid the money, they don't have the option period. No option fee, no option period. Contract, however, remains intact. In fact, like I said, even more intact than it was because the buyer has now lost the opportunity to change their mind and walk away. Worst thing that can happen here to a buyer, they don't deliver either. They don't deliver the option fee and they don't deliver the earnest money. By not delivering the option fee, buyer has no option. By not delivering the earnest money, the seller now has the right to terminate. But what if the seller decided not to terminate? If the seller said, that's okay, I'm good. Now all of a sudden we have a transaction where the buyer is just as locked in as they would have been because they have no option fee, no option period. So it's imperative that we make sure that we understand what happens because we want to make sure that we advise our clients properly. If for some reason this buyer decides they want to walk away before the option fee has to be delivered, they still have to deliver the option fee. If they have 3 days to deliver the option money, and on day 1 or day 2, the buyer decides they want to back out, the buyer still has to deliver the option fee because with no option fee, there's no option period. With no option period, the buyer doesn't have the right to walk away in any period of time, including day 1 or day 2. So they still have to deliver the option fee. So make sure you understand all of that because we have to advise our clients the best way possible. We don't want to advise them that, hey, if you don't deliver the money, don't worry about it. The deal will fall apart because that could be the furthest thing from the truth. So I just thought we'd go ahead and throw that in there.
Down that too, just for everybody, for our agents and the ones that are not out there, that's very serious. Don't give legal advice, period. Second of all, if you give them wrong legal advice, you're held to the level of an attorney there. So that's malpractice by telling them that something that's not true. Non-delivery of earnest money, non-delivery of option money does not kill the deal. And you would advise them improperly, your license is in risk. So don't do that.
Yeah. Absolutely. Thank you, sir. All right, let's move on. Section 6, title policy and survey. Title policy information remains exactly the same. No real changes here regarding the 9 exceptions that are there. And of course, at least for us, make sure you answer this question here about section number 8 as to whether or not we're going to ask the title company to amend their title policy to include shortages in area or not. Because if you leave it blank, then the title company doesn't know what they're supposed to do with that. And of course, not answering it is not an answer. Sometimes I know people think that, well, if we just leave it alone and we don't touch it, that means it's not going to apply. No, that's not really true. No answer is no answer. It's not an answer of any kind. It's not a not applicable. It's not a none. It's not a no. It's just no answer. And that can create issues, of course, as well. So make sure you don't leave blanks in our contracts. All right. when it comes to the survey, there's not really any real changes that have taken place from the last version of the contract. However, there's just a couple of things I wanted to go ahead and throw out there anyway, because even though they applied on the last version of the contract, we didn't have the last version of the contract very long. So I thought maybe I'd go ahead and throw in some of those things that changed last time versus this time, because they're still important and there's still changes that are there. And so the second option here, when it comes to survey, we know option number one is where we're expecting the seller to deliver an existing copy of their existing survey and also filling out that T47 or the 47.1. The T47 is a disclosure by the seller how the property has changed since the time the original survey was done, or the survey that they are supplying was done. And so the T47 has to do with a notarized document that will notarize the signatures of the seller as they are disclosing what changes have taken place since their version of the survey has been done. The 47.1 is essentially the same document. The only difference is that it is not notarized, but there's some more personal information about the seller that has to be provided on the form. And so even though the 47.1 allows the seller to not have to get the document notarized, a lot of them are still preferring to do the T47 because it contains less personal information. The 47.1 contains birth dates and certain personal information that the T47 does not. So if you want to get away from having to notarize it, then you go to the 47.1. But if you go with the 47.1, then the seller is going to have to be willing to provide birth dates and things like that, some other personal information as well. Section 2, it gave the buyer the choice of whether or not they want to do a survey or not. So if you've seen the farm and ranch contract, you know that there are actually 4 options here when it comes to survey. There is a 4th option on the farm and ranch contract that says no survey is required. Rather than doing that, and I don't know why the Real Estate Commission decided to do it this way on the regular residential contract versus the farm and ranch, but they did. And so they created an option in certain types of transactions, cash deals, maybe things like that. The buyer may not care about whether or not they have a survey or not. An investor paying cash may not care less as to whether or not the fences are where they're supposed to be or any of those things. They may not care. And so they put in one additional word here, may, right here. So now it gives the buyer the option. They don't have to obtain a new survey. It says they may obtain a survey. So if the buyer decides, I don't really care about a survey, you can still mark number 2 and put in the number of days, 20, 25 days, whatever number of days you want to put in there. If the buyer elects not to do a survey, then they have not breached the contract because it says buyer may obtain a survey. They decide not to, they're not in breach of contract. They just exercise their right not to. However, if the buyer decides not to get a survey, then they have lost one of the ways to walk away from this transaction. And that's what I've highlighted down below. If the buyer just fails to obtain the survey, they decide they don't want one, they decide I'm going forward without it, buyer may not terminate the contract under paragraph 2B of the third-party financing addendum because the survey was not obtained. So third-party financing addendum section 2B talks about approval. Buyer approval, property approval. Part of property approval is survey. If the buyer elects not to do a survey, then they have lost the ability to walk away based on property approval if there's some issue that pops up later on when they finally get around to doing a survey, or they find out later if whatever the issue is something that would have been identified by the survey, and they find out, they don't have the right to walk away because they elected not to do the survey. So they lose that opportunity. The lender, if there's a lender involved, most likely is going to require one anyway. So this may or may not apply. It just says that in the event, if there's maybe a hard money lender or somebody like that who doesn't care, then in a situation like that, if you don't do the survey, you don't have the right to walk away based on something the survey would have shown. So, all right, go move on a little bit further. Under objections, everything's still the same there. Only a couple of things to point out there is that there's a whole bunch of language down here that a lot of times people just kind of skip over that talks about a cure period. It talks about that if there's some issue that shows up either on title or on a survey, or if the buyer finds out they cannot use the property for a certain activity, they can't just walk away. The buyer can't just say, "Ooh, there's a title issue. Oh, there's a problem on survey. Oh, I can't use the property for business purposes, so I want out." You've got to follow the steps. You have to object within a certain number of days. And this is one of the reasons why this number of days is really critical. And a lot of times it gets missed. I can't tell you how many contracts we see where nothing gets filled in here, where they feel like, oh, well, I don't really care. I don't have an issue here. Like there's some certain activity that I want to use the property for. They feel like that this number of days only applies to this. That's not true. This number of days actually applies to three things. It applies to defects, exceptions, or encumbrances to title issues. It also, this number of days includes information disclosed on a survey. And it also would include a number of days to object if there's some certain use or activity the buyer wants to use the property for. So, like I said, one of those things show up. We have a certain number of days to object in writing to whatever that issue is. You can't just say, there's a title issue, I want out. There's a survey issue, I want out. You have to go through the steps. And the steps are, first of all, written objection. You have to do a written objection. And I say you, and I mean the buyer. The buyer has to do a written objection that would be delivered to the seller's agent and also to the title company. And you could send it to the lender too if you wanted to. That's fine. The lender's going to see it too. And so you would send it in there. And once that has been received, the seller now has 15 days to cure that issue. They now have 15 days here where they can try to cure the issue. It's called the cure period. If they can't get it cured within 15 days, then the buyer has 5 days after that, into the 15 days, to terminate and get their earnest money back. So you've got to go through the steps. Objection, 15 days, 5 days. Now, if the seller knows they're not going to be able to cure the objection because it's a deed restriction or something and they know there's no way to fix it, then maybe this can be sped up. Maybe the seller can come back and say, hey, look, there's no sense in waiting 15 days. I know we're not going to be able to get it done. So go ahead and send your termination. And both sides agree to that, that's fine. But otherwise, you've got to go through the steps. The buyer can't just elect to walk away. It'll have to come through the seller. Got to give the seller their 15 days if they want it to try to cure whatever that issue is. All right, just wanted to throw that out there too. There's a lot of lines there that somehow gets missed a lot. The title objections are all the same, except they removed one. So if you remember, there used to be 12, and the last one used to have to do with identifying the mud, identifying if the property was in a water district, if it was in a municipal utility district or something like that. We still have to do that. It's just not here. We'll see it later on when we get into section 22, where it shows the attachments to the contract. It'll be there. So that one they just picked up and moved. No real changes there. Everything that is there has always been there. No changes. All right, so we'll move on.
Take some water. Yeah.
Thank you. Yeah, I think I'll do that. You all think that's water.
Yeah, right. I was say, or a beverage of your choice.
If it starts getting screwed up towards the end, you'll know it was something else. All right, section 7, property condition. We have one major change here. The first parts are all the same. 7A regarding having access to the property and doing inspections, and the fact that the seller has to keep utilities on throughout the entire transaction. All that stuff is still the same. No real changes there. B, of course, talks about the seller disclosure notice. The only thing that they did add, because now there are other disclosures that get talked about in the contract, where it used to just say disclosure, they now have added in which disclosure they're talking about. So throughout the contract form itself, there were times where it used to just talk about the disclosure. And when it talked about the disclosure, we assumed it meant seller disclosure because it usually did. Now we have a groundwater disclosure. We have a surface water disclosure, which we'll see here in a minute. So now they make it clear exactly which disclosure are they talking about. So seller disclosure, all that information still the same. Three options. Either the buyer has already received it, made their offer based on reviewing it, or number two, we're going ahead and we're negotiating the deal, but I haven't seen the seller disclosure yet. So making it clear that within a certain number of days after the effective date of the contract, the seller will provide a completely filled out seller disclosure, give the buyer the opportunity to review it. If the buyer doesn't like what it says, they have up to 7 days after the effective date to walk away. And of course, if they walk away based on this, they will get their earnest money back. They will not get their option fee back. And I know that question comes up an awful lot. So let's just clear that up right now. Once that option fee is paid, it is never, ever, ever, ever refunded, ever. That money now belongs to the seller. The only way it gets credited, and the Real Estate Commission does draw a distinction between those two words, refund and credit. Refund is giving the same money back. That never happens. Once that money has been spent, it belongs to the seller. The contract does allow that if the buyer gets to closing, if this deal gets all the way to closing, the seller will now credit that money back. They will give them credit for money already paid. They're not giving them the same money back. They are crediting that money back for money that's already been paid. That is the only way that the buyer will ever see any of that money ever again. Once they have paid the option fee, that money's gone. So in any of these scenarios that we see in the sales contract that allows the buyer to receive their earnest money back, you don't even need to ask the question, what about the option fee? Because the answer is no. They don't get their option fee back. Only if they close, they'll get credit for it. All right, so that third option there, this happens to be a type of transaction that does not require the seller disclosure. So there are 11 exceptions to who does not have to fill out a seller disclosure. I wish I had pulled those up and had those there to share with you because a lot of times that gets missed as well. A lot of times we think investors who've never lived in the property, they don't have to fill out a seller disclosure. Yes, they do. Somebody who's selling the home themselves for sell by owner, they don't have to fill out a seller disclosure. Yes, they do. Somebody who purchased a property as a foreclosure and now they are selling the property. Well, since I got it as a foreclosure, I don't have to fill out a seller disclosure. Yes, you do. So most instances, or a lot of the instances where we feel like that the seller doesn't have to fill one out, they really do. And so the seller disclosure, of course, is going to talk about knowledge, the seller's knowledge, their knowledge of any defects in the property. Not whether or not the defects exist, it's whether or not they have knowledge of defects. And so every seller could tell whether or not they know of any defects that are in the property or not. That's the level they're held to. They're held to the level of disclosing what they know, not whether or not it's there. What do they know is there? So there is a difference there. All right, C, seller disclosure lead-based paint. We know what that is, of course. Property built prior to 1978, federal law still requires that the seller disclose whether or not they have knowledge of any lead-based paint or lead-based paint hazards on the property. And of course, it's not just limited to interior paint. It could also be exterior paint. So either of those. And if the house was built prior to 1978, the seller does have to fill the document out. One of the main issues that we see on this document is that it doesn't get filled out completely. One of the federal requirements is that the buyer has to receive a 21-page pamphlet that is called Protect Your Family from Lead in Your Home. That is not something that can be given to the buyer. It is something that is required by federal law to be given to the buyer, and it has to be acknowledged on that addendum that it was received. That's in Section D. Section D2 of that lead-based paint addendum is where you put a check mark there, and once the buyer has signed the addendum, that is their acknowledgement that they have received that document. If they don't receive that pamphlet, that is a violation of federal law. So don't let that pass by. They need to get that. D, of course, talks about the property being sold as is. As is means based on what the buyer's understanding is of the condition of the property at the time of closing. So throughout this transaction, they learn about the condition of the property. They first learn about it most likely from that seller disclosure, where the seller tells them what they know. Then, of course, they have inspections done. That gives them a little bit more information, or maybe a lot more information. There may be something that shows up from contractors who do bids on repairs. There may be information that comes from an appraiser when they come out and appraise the property. So all of this information is being gathered during the course of the transaction. As of the day of closing, the buyer is accepting the property in that known condition. So, of course, that means if something shows up later on, after the closing, if they find some item that pops up that they were not told about, the buyer has every right to try to determine whether or not somebody knew about that information and didn't disclose it. So that could be an item that could go against the seller, could go against agents, it could go against whoever had knowledge of this information regarding the condition of the property and did not share it. If they had it and they didn't share it, they may have an issue. So, of course, we check one box or the other. Yes, buyer is willing to accept it as is. That's where we are right now, based on what I know right now at the time of contract. Based on what I know right now, I am accepting the property in its current condition. However, inspections are still going to be done. There are probably going to be some bids that may be done. There may be some other things I learn along the way that give me the opportunity to ask for more. Just because I'm accepting it as is based on what I know right now doesn't mean it's going to stay that way. And of course, number two, if I already have some items that I know I want the seller to repair, I would put those items in there. Please make sure you take note of this set of instructions here. Don't put in general phrases like subject to inspections or to be determined at a later time or determined after inspections or any of that. Only specific items. Broken window in one of the bedrooms, whatever it is. But that would be specific, not anything general.
You could say replace the roof or whatever, condition of the offer, right?
Anything you already know.
Now, this is one that oftentimes comes up for our agents. The things you see visually, if there's a big hole in the wall walking in and you're not addressed here, you're saying, yeah, I see it. I'm going to buy it. This price includes that hole. But the things you don't see don't include them. So, yeah.
Right. All right. Excuse me. Section E, lender required repairs. Those would be things that show up in one of two places, an amendment or appraisal, or maybe both, but it's probably going to be one of those two things. that the lender finds out about something somewhere along the way, either once the appraisal is done and the appraisal comes in and says, yes, that value of $425,000, that value is there, but only if these items get corrected. Those would become lender required repairs. The lender's going to say, we're going to go along with what the appraiser says. The appraiser says the value's not there if these things don't get done. And so based on that needing to be done, those are going to become lender required repairs. Depending on what the things are that they might see in an amendment where the buyer has done their inspections, they have found some issues, they have asked the seller to repair, seller has agreed to repair, the amendment gets signed, then that amendment is supposed to be shared with the lender. And so now the lender has the opportunity to see some of those things and they may decide, you know what, that's pretty important to us too. So we want those things to be taken care of as well. That's why a lot of times instead of that, you see in lieu of doing repairs, the seller tries to throw some money at it. We'll pay some money towards your closing costs or something like that. Now, we've had a number of times where the agent says, where do I put the information that says that we're doing this in lieu of repairs? It's like, why do you have to say it's in lieu of repairs? They're not asking for a reason why. If the seller is now picking up $4,000 of the buyer's closing costs, just make that change. You don't have to go and explain why. Nobody's asking why. Don't give more information than you're required to give, but give the information you are required to give. F, completion of repairs and treatments. This one sometimes gets overlooked too, where it talks about the fact that who has the ability to do repairs, because it says it's pretty clear that repairs are supposed to be done by somebody who is either licensed to do that repair, or if the repair itself doesn't require a license, somebody who is commercially engaged in the trade of providing that repair, which means they make their livelihood that way. So based on that, unless you have otherwise agreed to in writing that you see up here, then most of the time the seller is not really authorized to conduct their own repairs. And this is one of those things that if the seller wants to do their own repairs, you need to ask permission and not forgiveness, because once it's done, then it's too late. And now the buyer may have the inspector come back out and check it, and it may not have been done right. Now all of a sudden we've got this issue where the seller says, well, I already did it once, I'm not going to do it again. If we're going to agree to allow the seller to do the repairs themselves, that needs to be negotiated right along with the repairs. That needs to be done at that time. You don't want to do it, have the seller do the repairs, and then come back later on and say, oh, well, you can go back and check them, but I've already done them once. I'm not going to do them again. That can cause more trouble than it's worth. Section G, environmental matters. This one doesn't really apply too much. We don't see it applying that much when we get into regular residential real estate. 3 items: toxic substances, wetlands, endangered species. If we're concerned about any of those 3 things, then there is an addendum that we can attach to the contract that allows the buyer a negotiated amount of time to have an ESA, environmental site assessment, done to check on those items. If we're doing regular residential real estate, for the most part, neighborhoods, subdivisions, this is not really going to be an issue. It could be an issue maybe out in the suburban area or far suburban areas from time to time, but other than that, probably not so much. H, residential service contracts, of course, having to do with home warranties. Buyer can get a home warranty if they would like, and then the seller may reimburse them up to a certain amount, whatever we put in there.
Hey, Don.
Yes, sir.
Question says, what do you advise on an estate property in the seller disclosure?
So if it's an estate, if they're selling it as an estate, that is one of the 11 exceptions. If it is somebody who is either an administrator or an executor of a will. So if it's an estate that's being sold, the property that's being sold is part of the estate. If there's a valid will, then there's somebody called the executor who is responsible for selling that property. If there is no valid will, then the court appoints somebody called an administrator to do the same thing. And so that, that type of transaction does not require a seller disclosure. Now, two things to keep in mind about filling out the seller disclosure. Number one, just because you don't have to fill it out doesn't mean you can't fill it out. I think a lot of times it really behooves us to go ahead and fill it out because it kind of gives us a guide. If we fall into one of those categories and there may be a number of items that need to be disclosed, then maybe we can go ahead and use that form because it kind of gives us a guide of the things that need to be done. The second item that we need to make sure and remember is whether we have to fill out that document or not, every seller, every seller is required to disclose what they know regarding the condition of the property. So that's why I say it's not a bad idea potentially to go ahead and fill out that form anyway, even if it's not required, because it makes it easier for us to know exactly what is it that I have to disclose. Because just because we don't have to fill out the document doesn't let us off the hook. This is not a let the buyer beware state. This is a disclosure state. And so no matter whether we have to fill out the document or not, we have to disclose what we know. That's why I said it might be a good idea to go ahead and fill it out anyway. That good?
That's perfect. Thanks, sir.
All right. Then we go to letter I, brand new provision having to do with a seller disclosure about groundwater and surface water rights. So this is a result of the last legislative session for the state of Texas, where they passed a law that talks about the fact that fresh water is becoming such a precious commodity in parts of the state. Even though we've had a ton of rain here a little while and the drought monitor looks pretty good right now, there's still aquifers that are getting depleted. There's still a lot of surface water that is getting depleted. If you're in Corpus Christi right now, the lake that supplies fresh water to Corpus Christi and the surrounding area is down to 11% of capacity. Even with all the rain that we've had, it was at 8%. Now it's at 11%. And of course, we have the issue with the data centers that are being built or at least being contemplated, the amount of water that they utilize. It's getting to the point where water is such a precious commodity that they had to step in and start creating some restrictions, regulations around that because we have so many people moving in. The number of people moving in is so great that we had to do something. And so this reflects what the state legislature came up with last year. And so for most of us, in a regular residential transaction, we're probably going to be checking number 3. And so think of this as just like the seller disclosure, because it is. It's a seller disclosure, this time not about condition, but about water. And so just like you would fill out, you would make sure that if you're doing the seller disclosure back up here in section 7, you don't leave all 3 of those blank. You answer number 1, number 2, or number 3. You don't leave it blank. Well, take that same frame of mind to 7I. We don't leave these blank either. It is number 1, number 2, or number 3. Do not leave it blank. Most of the time, it's going to be number 3. So number 1 is kind of just like the seller disclosure. In this case, the buyer has already received the water disclosure. So this seller disclosure about groundwater and surface water rights, this is a listing document. This is a listing addendum. Just like the seller disclosure gets filled out at the same time as your listing agreement, so does this. This is now going to become a required form if it needs to be filled out. This is going to be a required form when you list the property because you're going to have to provide it to the buyer's agent. So if you have to provide this, if this is going to be a requirement, stick it in your attachments on MLS right along with the seller disclosure. So that's fine. It can go there. So buyer has already received the seller water disclosure. So the seller already knows the answers to these questions. And so if they already know the answer, they already know that it needs to be filled out and they fill it out, then the buyer's already received it, made their offer based on that information. Second one, they have not received the information. Again, we're going ahead, we're negotiating the contract with the understanding that the seller is going to fill it out within a certain amount of time, whatever number of days we put here, within a certain number of days. And just like the seller disclosure, once the buyer receives it, they have 7 days to review it. If they don't like what it says, they can walk away. The third option is where it is not required. And in order for it to not be required, these 5 things all have to be true. So you just take them one statement at a time and say, is this statement true? All right. So number one, or letter A, seller is not aware of a water well on the property. And that means whether it is in use or not, any well on the property at all, whether it's capped, whether it's abandoned, doesn't matter. If this is a true statement, seller is not aware of a water well on the property. Fine. Let's go on to number 2, or letter B. Seller is not aware of a pond, lake, or water tank on the property. All right. So if there's no well, there's also no pond, no lake, no tank on the property, we're still good. Now we go to letter C. Seller is not aware of any certificate of adjudication, certified filing, or permit for surface water rights associated with the property administered by the Texas Commission on Environmental Quality. I have a little bit of additional information on this. We'll get to this in just a minute. I'll pull it up and show you what they're talking about there. D, seller is not aware that any groundwater rights to the property have been severed, sold, or leased in whole or in part. And if all of those are true, then letter E, the property receives water only from a municipality, which would be a city inside of city limits, a municipal utility district, which of course is a MUD, or some other special district, water supply corporation, or private water supply company. For most of us, it's probably going to be a MUD unless we're inside of city limits. That's usually one of the 2 places. There are some properties out there that belong to a private water company where they maybe don't have water taxes, but they have a water bill. So if all 5 of those things are true, then we would check number 3. But let me go and pull up the information regarding C and D, so you know what we're talking about here. I think I may have lost that page. Hang on just a second. All right, so it's on our same page that we had with the legal holidays, but it's a little bit further down. All right, so surface water, this is letter C. This is what letter C means when it comes to surface water rights. It says you have to disclose any lakes, rivers, or streams that are on your property and whether you hold permits to use or divert that surface water. So surface water in the state of Texas belongs to the state of Texas. And so the rule, if you remember your real estate school stuff, riparian rights. And so riparian rights talks about water that moves through your property. So that would be like a river, a creek, a stream, or something bio where water runs through your property and then continues on its way, eventually dumping into a larger river or the bay system or whatever. So the rule says that as that water passes through your property or along your property, you have the right to enjoy it, but you do not have the right to dam it up. You don't have the right to bottle it up and sell it. You don't have the right to divert it in any way. That is not your water. It belongs to the state of Texas. However, there are times where the TCEQ, Texas Commission on Environmental Quality, will allow it to be diverted. Maybe it needs to be diverted to fill up a reservoir. Maybe it needs to be diverted to fill up a lake or whatever. You only have permission to do that if the state of Texas gives you permission to do that. And so this would be a disclosure that, yes, I have that scenario going on right now where there is water that passes through my property or water that's sitting on my property, and I have permission from the state of Texas to capture that money and that water in some way. And so for most of us, that's obviously not going to apply. D has to do with groundwater. So groundwater, of course, belongs to the owner. So surface water belongs to the state of Texas. In most instances, groundwater belongs to the seller, to the owner. And so this asks the question whether or not whether you, as the owner of the property or the seller of the property or some previous seller, shared your groundwater rights with somebody else. Are you allowing a next door neighbor to tap into your well or something like that? If you already would have to disclose if you had a well on the property, but have you allowed somebody else besides yourself the right to some of your groundwater? If so, then you would have to disclose that. And so both of those, C and D, are saying we're not aware of either of those things. We are not aware that we are involved in a situation where the state of Texas has allowed me to divert the water or dam it up or divert it to someplace else, or I don't share, and there's no one else who shares rights to the groundwater. So those are the questions that get asked. And this, of course, is a seller disclosure. The seller is the one who needs to be answering these questions. You can't answer these questions for them. These are questions that they need to answer. All right, go back to our contract here. Here. All right. So did I see some questions pop up?
Looks like Raoul popped in there. That's all. An agent asking if the list of the 11 statutory exceptions were a seller disclosure notice is not required could be added to the Rural Smart Agent downloadable section. I think we have that, didn't we? If not, we'll add it. The 11 exceptions. So,
I think I added it in RSA in the download section. I'm pretty sure I did.
yeah, I thought so too.
Yeah.
We'll double
Yeah,
check
we had
later.
a Ron agent asking if he couldn't find them, so if they were able to be added. I did mention they were already added. We just haven't had a chance to find them, I guess. Yeah.
Yeah, I think we did. I think we did. Content. Let's see.
Thank you.
Isn't it? Is it there?
Yeah, I don't see it.
Well, then we'll get it added. There we go.
We'll get it at it.
I can't find it either.
I thought I added it.
It's okay. We'll get it there. We'll add it tonight. Let's see.
Yeah, I don't see it. So yeah, definitely we'll get it added in.
Perfect. Thank you.
Sure. All right. Section 8, there was nothing I could mark here, but they actually did make a change, and the change is they took something out. So Section 8, broker or sales agent disclosure, they really talked about two different things. One, it talked about certain relationships that we have to disclose to the other side. But the second thing it talked about, it was a statement where it said that compensation was discussed in separate written documents, that it was in separate written documents, which of course was a listing agreement and the buyer representation agreement. Well, that statement's not true anymore because it is right here in the body of the contract. That compensation is talked about in the body of the contract. So they removed that section that talked about that compensation is discussed in separate written documents. It's not discussed just in separate written documents anymore. It's still talked about in the listing agreement and the buyer rep, but it's also talked about in this document itself. So they had to take that language out. Section 9, closing. Everything's still the same here. No real changes there. Possession, no real changes here. The only thing that really was added in the last version of the contract, it has to do with having to do with smart devices, where smart devices, of course, would be any app or platform or program that a seller might have that controls equipment and systems inside of the home, that once that home is closed, the seller is now required to delete all of those out, that they are required to have no more control over equipment, systems, air conditioning systems, lighting, whatever, that they are required to delete those and remove them from use. So that's what that is. Special provisions, still the same. Think of this as this section of the contract, think of it as having barbed wire around it with maybe a gate. We try to stay away from this as much as we can. Every once in a while, we might have to venture in there, but if we have to venture in there, of course, at least if you're here at HomeSmart, Marty would have to approve anything that gets placed in there. Then we get to the fun one. Section 12. All of Section 12 is highlighted because it is all totally different. And so where we were used to the old contract, I say old now, the last version of the contract, Section 12A1B. You probably heard that 1,000 times. Section 12A1B always talked about how much commission or how much compensation the seller was going to pay to the buyer's agent. Well, there is still a blank in Section 12A1B, but it no longer has anything to do with compensation. Why the commission decided to create this provision and put this blank here, I don't know, but they did. So Section 12A1B, where it's been hammered into your head, I know that it's about compensation, compensation, compensation. Erase that because it's not. Now, this blank has to do with seller contribution to buyer expenses. So let's take a look at it. And so 12A all has to do with expenses. And 12A1 all has to do with seller expenses. So everything that is in number 1, which includes 1A and 1B, these are seller expenses. So 12A1A, these are your typical seller expenses, things that the seller typically pays for. B is where we would go if we are asking the seller to pay something towards buyer closing costs. Look at what it says. An amount not to exceed a certain amount of money to be applied to buyer's expenses other than brokerage compensation. So whatever number goes in here has to go only towards buyer closing costs. And we know that there's a limit that if this is a financed transaction, Every type of financing has an upper limit. There is an upper limit to how much the seller can contribute. So if we're on the buyer side of the deal, know what that number is. Make sure you know, probably talking to the lender is a good idea to make sure that you don't put a number that is too big in this blank. If the number you put in here is too big, then whatever is not used is just not used. It's not going to go to the buyer any other way. You're not going to be able to, the seller's not going to cut the buyer a check for the difference. It's just money that did not get used. Look at what it says, an amount not to exceed. Well, if I have $7,500 in there and the maximum amount that the seller can pay towards buyer's closing costs is $6,000, I have complied with the contract. 6,000 does not exceed 7,500. So there's no further requirement from the seller to do anything. They paid as much as the lender allowed, and that was it. Make sure you know what that number is, because you know the seller is not agreeing to pay a certain amount here because they, based on their love for the buyer. The only reason they're agreeing to pay money towards the buyer closing cost is that the sales price is high enough to cover that. And so if I put too much money in here, the seller is not going to have to reduce the sales price of the house. They could keep the sales price where it is and save some of that money. So make sure you know what that number is. So it goes towards buyer closing, or it goes towards buyer closing costs. Section 2 has to do with buyer expenses. So these are expenses that the buyer would typically pay. And so they go through the list. So of course we know the seller has their own list of things they typically pay for. The buyer has their own list of things they typically pay for. Amazingly enough, a lot of times the actual number comes out pretty close. The buyer, of course, has a lot more stuff. If there's a lender involved, they get nickel and dime to death. So there's a lot more charges, but the amounts come to about the same thing that you might see that the seller might have to pay. They just have bigger charges and fewer of them. Now we get to 12B. New provision, completely new provision that talks about compensation. Brokerage compensation. Of course, they're going to have to throw in the obligatory language now that the NAR lawsuit had to make sure that we put in the information that commissions are negotiable. And so that's what it says, brokerage compensation not set by law and is fully negotiable. Each party shall pay their respective brokers pursuant to the terms of the parties' obligations to compensate their brokers contained in separate written agreements. So now they've moved that, what was in Section 8, they move it here and say, yeah, there is a place where there are separate written documents that talk about compensation. In the listing agreement, the new listing agreement talks about how much the seller will pay the listing broker. End of statement. That's it. That's all that goes there. There is no more broker to broker compensation. Not exist. The forms that used to allow that, the 2401 and the 2402, they are a thing of the past. You want to find those, go to the museum because they're not out there anymore. So now the listing agreement talks about is going to pay the listing broker. The buyer representation agreement discusses how much the buyer is going to pay the buyer's broker. That's really the way it has always been. It's just that it could be masked or disguised by the way that it was filled out and the language that was used by the agent to that particular party. That does not exist anymore. That's the way it needs to be presented. Listing agreement. Seller, here's how much I am charging you to represent you in this transaction. Buyer, here is how much I am charging you to represent you in this transaction. Well, is there a way to flip it to the other side or transfer it to the other side? Maybe. We're going to try, and here's where we try. So notice it says here in bold print, the contributions under 12B1 and 2, that's these two lines here, shall be applied to and shall not change the party's obligation to pay compensation pursuant to those agreement. What is that saying? It's saying, okay, if either one of these boxes gets filled out, then whichever side is agreeing to pay, they are agreeing to pay in addition to what their separate document said. Listing agreement, seller paying listing broker. Buyer rep, buyer paying buyer broker. If one of these two boxes gets filled out, then we are creating an additional requirement for that party. So if we mark the first one, we mark number one. Number one, we check this box, we stick in 3%. What are we saying? We're saying that the seller will pay 3% of the sales price that's going to be applied towards the brokerage compensation that is owed by the buyer to the buyer's broker. That was created by the buyer rep. When the buyer rep got signed, that committed the buyer to paying the buyer's broker. Here we are trying to transfer that responsibility away from the buyer and to the seller. So if we're successful, if the seller signs off on this contract, the seller is now paying their broker whatever they agreed to in the listing agreement, plus whatever we agreed to here. Whatever we agreed to in the contract, the seller is now responsible for both. That's not unusual. We've seen that before, where the seller ends up paying both sides. That can still happen. You just have to do it that way. It cannot pass through the brokerage anymore. It can't be seller pays listing broker shares with buyer broker. Does not exist. That part does not exist anymore. We are taken completely out of the equation when it comes to the payment of compensation, of doing the paying. It is going to either come from just the buyer or just the seller. All right, so that first box, we have now transferred, if we put a number in here and the seller signs off on this contract, we have now successfully transferred whatever number is there away from the buyer's responsibility. It has now become a seller's responsibility. Now we have a section 2, totally new to what we have looked at before. Section 2 allows a buyer to pay a certain amount of what was agreed to in the listing agreement. So if we put a number in here, we put 3% in here, this is saying that the buyer will pay a certain percent of the sales price to be applied towards the brokerage compensation that is owed by the seller to the seller's broker. So now if we put a number in here in section 2 and the buyer signs it, the buyer is agreeing to not only pay their broker, they're now also agreeing to pay the listing broker. So it's an addition. These are in addition to whatever has been agreed to in the listing agreement or the buyer rep. So I hope that's clear. I didn't see if any questions came in. We have any questions come in on that?
No one jumped in yet, but they're more than welcome to. Any questions, anybody? Nope.
Okay. In that case, we'll move on. So Section C talks about expense limitation. Already mentioned the fact that there are limitations on what can be paid by the seller on behalf of the buyer, or actually anything that can be contributed to the buyer in any way, whether it come from the seller, the agent, or whoever. So this says if a governmental loan program regulation prohibits the buyer from paying certain charges or fees, then the amount of the concession that we put back up here, back up here, whatever we put in here, first has to go towards what we call non-allowables. And so there aren't a great many of those anymore. There used to be a lot of non-allowables. If we were dealing with FHA or VA, there were certain charges that the buyer was not allowed to pay. In other words, they had to be picked up by the seller. And so if there are charges like that, and I think VA still maybe has one or two regarding pest control or termite certificate, things like that, then whatever number went in that 12A1B is going to be used first towards those fees. Then it says, then if there's any money left over, which there probably will be, then if there's any money left over, the amount of the concession shall be first applied to pay such prohibited expenses, the non-allowables, and then to other buyer expenses, but not to compensation. So really that's a reiteration. They're just reiterating what was said up above, that this money cannot be used for compensation. It can only be used for buyer expenses, buyer closing costs, prepaids, whatever. But it cannot be used for compensation. All right.
I have a question, if I may.
Sure.
It's kind of going back to what you just said, because I'm trying to process what you said. Okay, so if my seller has agreed to pay 6% to the brokerage, right? And it's been discussed with the agent. All right, they're going to give, standard, we're going to give you 3% of that. When it comes to this new list with the 12A, 1 and B, I missed it because I'm looking on my phone and it's really small. How do we fill that out? In a nutshell, I just need to know how to do that because I have a contract pending right now, and I just want to make sure I get
first of all, we haven't looked at the listing agreement yet, but if you're in your listing agreement, you put 6%. What you have said is that the seller is paying you 6%, period.
Yeah.
You can't share it. It's not allowed anymore. You're not allowed to share your commission with the buyer's agent. So if you put 6% in there, then you're owed 6%, which has nothing to do with what's going to go in this contract form.
Okay, I'm with you.
Okay, so
okay, this is Samantha. What she needs to know is from an agent point of view is when you get the listing, the seller will pay you the 3% or whatever you want. And then when the buyer brings their client, they're going to negotiate and it will be like compensation, or it will be used for closing costs or for this buyer to pay their agent the 3%. They will require that on this form right here. I will be sellable paycheck, the B1, I believe.
So you're talking about paying
This, because what she's trying to find out, on the past we used to get 6% from seller, but now the 3% is being removed, you can say so. And what she's asking is like, if my seller agreed to pay 6%, the answer is no. You're just going to get whatever you're going to get from the seller. And then when the buyer comes along, the buyer is going to request for the seller to give money for the buyer so the buyer can pay their agent.
That's not allowed. It just said that the money cannot be used to pay compensation.
Rephrasing it, and instead of saying that this buyer can ask the seller for concessions for their closing costs, and the buyer can ask the seller in the contract to pay their broker on their behalf.
On top of
yes, on top of that. So it's what she's saying. It's just the way she's worded is a little bit different. But yes, in the contract, you would ask the seller to pay the buyer broker on behalf of the buyer, since the buyer's already obligated to pay the buyer broker.
That's right, Marty.
Yep.
Thank you.
Yep. It was just phrasing, that's all.
Okay, so the probability of us using B2 probably not going to happen, right?
Probably not. Yeah, it's going to be rare. I can only think of a couple of situations that we've had where it was an investor and they were paying so little for the property that the seller said, okay, yeah, I'll sell it to you for that, but you're going to have to pick up all the closing costs, including the compensation to my agent.
Okay.
Maybe
yeah, okay, that makes sense. Okay.
A short sale where the home sells for way less than what it's worth.
Yeah, maybe that could be a possibility. Any
potentially, usually the lien holder though will approve a certain amount for each side. They typically do, and they cap it up at what we've seen as well. Sometimes on those, it could be like we said, an investor. It could be a like an orchard or something buying the property. Sometimes they'll pay the agent, and then not have a commission on their side. So you never know. So.
Yeah, it could be a seller who has an agent, but the agent's not making a whole lot of money. Maybe they're doing it as a favor or something like that, and so the buyer can pick that up too. Yeah, there's some scenarios, but not very many probably. So, any other questions on this one?
Quick question. So Don, if my commission is 3%, right? And then my my buyer says, well, I'll cover 1.5 and then have the seller pay the other 1.5. Then we'll put it on both sections.
Right here under this, right here.
Yeah,
You put
yeah,
1.5
okay.
here.
Got it. Thanks.
Yep, you put 1.5 there. It's
And just a little
it's a
clarity.
different world.
The part where your buyer's paying it on your behalf, of course, you would provide your buyer tenant rep as well. So, yep.
So,
Okay.
yep, it's a different world. So this, I know in two or three of the scenarios we've talked about that we're charging the seller 6%. That understand that if you're saying that, I'm charging my seller 6%, that's exactly what you're saying, that I'm charging you 6%. And that would probably keep the seller from being able to do anything over here, to pay anything on behalf of the buyer, because you're getting paid 6%. And that seller may say, you're getting the whole thing because you can't share it with the buyer's agent anymore. So the negotiation with the seller needs to be just how much am I charging you to represent you? Period. That's it. That's the end of the conversation, other than don't be surprised if we get a contract in or an offer in where they also ask you to pay the buyer's agent. I'm not asking you to do that yet. I'm not going to ask you to pay the buyer's agent. I'm just telling you what I'm going to charge you for representing you in this transaction. Don't be surprised if this happens, but I'm not going to ask you to do it right now. I'm not going to commit you to doing it right now. We had that conversation with one of the agents today, which said that really with the changes that are here, it's really an opportunity. In a lot of cases, it's an opportunity potentially for the seller to pay less than they would have paid. If we were charging them 6% in the old way and we were keeping 3 and sharing 3, that was a commitment. That meant that the seller was paying 3% that was going to go to the buyer's agent. Well, what if you get an offer here and the buyer's agent only asks for 2%? You can do that because now the seller is not committing to anything at this point. When you take that listing, seller is not committing to anything towards buyer agent compensation. Not yet.
Hey, John, Melissa has a great question in the chat. It says, if I get a lowball offer as a listing agent and seller, and they request to have my seller pay the buyer's agent, title, warranty, etc., then the seller, I'm rephrasing her question just so more correct, can also ask the buyer to pay some of the listing agent's commission in a counteroffer, correct?
Absolutely.
That is correct, yep.
There's,
as long as it's the seller,
there's a place there for that.
Good question, Melissa. Yep.
Yeah, it really.
Hey, Dawn,
Yeah.
I have a question. I have a quick question. So let's say that I go under we're negotiating the contract, and so I'm representing the buyer, and I'm asking the buyer to compensate me 3%. And the seller comes back and they say, okay, we're going to compensate you 1.5%. My buyer has now said, okay, I'll pay the other 1.5%. So to communicate that to title that comes through our CDA, is that how we communicate that, or do we communicate that up front?
Yeah,
because it's in
you
our
can fill out the
listing and it's
CDA
in our
that way.
buyer's agreement, but they don't necessarily have our buyer's agreement.
Right, but don't be surprised if some title companies want to see
Ask you.
that
Yep.
representation agreement. They may ask to see that that buyer rep.
Okay.
And the reason they want that is they want to prove, obviously, a contract that tells them how to pay it. And so if the buyer agrees to it, CDA will be there. Oftentimes the buyer's agent agreement will say, yes, the balance is being paid for by the buyer, and here's my agreement showing that. So exactly.
Yeah, they want a paper trail. They want something to show that what that number should actually be.
And-
Yeah, because they're the ones doing the final paperwork and showing who's getting paid what.
Right.
Yeah.
Hingama, you're up.
Hi, everyone. Yes, I have a question about, I know when you have the listing and you say just whatever you get, you negotiated with listing, with the owner, and then the buyer comes in, you have to negotiate it before you put the contract to make sure if seller pays or buyer pays or something, or we just write it and then they look at it and they agree or disagree with it, how it
Either
works.
way, I mean, if you want to call a listing agent and say, has the seller indicated whether or not they would pay buyer agent compensation, then you can do that. That has not been very successful in the previous way that things used to be, when you would call the listing agent, ask the listing agent if there was any money available for the buyer's agent. A lot of times you couldn't get a hold of them, or they would say, it depends. That it depends on the offer and things like that. This gives you the opportunity to just put something in there, and submit it.
The great thing about this, Hangma, is that it makes all of it negotiable. So this offer is subject to the purchase price, the closing date, and buyer broker compensation. The seller can counter on any of that. I want to close earlier, close later. I want a higher purchase price. I want to pay less realtor fees. It's all on the table, which it never was before. So it's an offer that's included all those terms that you have to give to your seller and say, this is what your net is after all of these things. What do you want to counter on?
Okay, if you have a buyer representation and then whatever you have on that, the buyer is supposed to pay, correct?
The different,
They have to agree to that. We have to agree to that first. And then whatever seller pays and buyer pays, I'm so confused here.
Yep.
No,
The-
I don't
the-
think
it was like
you're right. That's exactly right.
You
That's
have
how
it.
works.
because
So you have,
before it was like you get 6% or 5% or whatever, ahead of time how much buyer agent will get.
right.
And that's
Well, you still do, but it's different now. So let's say that I have a seller. I'm going to negotiate a compensation for my time. That's my listing agreement. I say I have a buyer. I'm going to negotiate my time. I'm going to make. This is how much I make, whatever it may be, 3%, 4%, 25%, whatever the commission is. They've agreed to it. You know what you're going to make. Now in the contract, you're going to ask the seller to cover that. If they don't, the buyer owes it to you. So you know exactly how much you're going to make. You just don't know who's going to pay it.
Oh, okay. So yeah, we have to explain that to buyers now
Mhm.
because everything goes on the things social is like, oh, seller will pay it for pay yours or whatever. We agreed to this, but that happened. I don't know.
Yep.
As I said, I'm just confused. Well, I learned more.
And that's what got us in trouble.
Yeah.
Because that's not the way that conversation was supposed to go with the buyers, that, hey, I'm going to charge you this, but hey, don't worry about it. I'm going to pick it up over here from the seller. That's not the way those conversations were supposed
Not
to.
anymore. Yeah.
And they are bit by bit transitioning us to the point to where they are forcing us to have the conversations that we were supposed to always be having. That is just getting to the point where that the exact same conversation that we have with the seller, this is what I'm going to charge you, is exactly the same conversation that we're supposed to be having with the buyer. Here, this is what I'm going to charge you. It's exactly the same conversation on both sides of the deal. It just never was that way. It was, okay, buyer, here, go ahead and sign this thing. It says 3%, but don't worry about it. I'm going to pick it up over here. That's the part of the conversation that never was supposed to happen. But we felt safe in saying that because on the listing side, that we were pretty sure that the listing agent had said, okay, seller, I'm going to charge you X amount and I'm going to share this much with the buyer side. And that's not the way that conversation was supposed to go either.
Yeah. Okay.
One
Well, as I
little,
said, I have to learn how to talk before it was
right.
different a little bit.
In one little
And I'm
nuance.
most of the time in a buyer side, so.
We're all baby agents all over again.
Yep.
Yep.
One nuance to this, by the way, everybody, is it used to be able to say to the seller, say, I'm going to offer a certain amount of the total commission I'm charging you to provide marketing material to draw agents who bring buyers. Now you don't have that argument. Now it's like, this is what I charge. I'm going to market it. Now to bring buyers, they probably need agents, and agents probably want to be compensated. So be aware they might bring an offer where they want compensation. A little different conversation.
You're right, Marty. And I've got hopefully 2 listings coming, and I've already started having conversations with them, my sellers, and explain, say, hey, when it's time for us to sign a listing agreement, I will no longer be sharing commission with the buyer's agent, setting them up so they can already be thinking about, okay, if a certain price comes in, am I going to accept paying, some towards the buyer's agent or what? Just getting their mindset ready for the change as well. So when things happen.
One more thing I want to ask is if seller will say, okay, I will pay buyer agent certain amount, and then we have representation from the buyer representation that they're going to pay something. So if seller will pay part of that commission, and then buyer is like, for example, if buyer has 3%, and then like seller says, I pay 1.5, and then we have to have an addendum for that, addendum for that to,
If you're not going to collect the other 1.5 from the buyer,
yes.
yes, then you need to do an amendment to buyer tenant representation agreement, TXR 1505,
Okay.
and reduce that amount.
All right. Thank you.
I believe also in a good way is, since we're all babies to this in a way, it's also encouraging us to go that extra mile and becoming more almost like mathematicians, and having that buyer's closing costs or net, seller's net proceeds, in a way, kind of making us a little bit more savvy in our field.
There's 2 great questions in the chat, Don and Raul. The first one's from Rose. This is the one we're going to see a lot of now lately. It says, I have a listing since the old time of the old listing at 6% for the broker, 3% to the buyer broker. They now have an offer where the buyers ask for 3% to cover the buyer broker. She wants to know if she has to amend her listing agreement. And that is correct. You do. So you won't have your seller paying 9%. So yes, you would adjust your listing agreement to represent down to that 3%. And then Laura says, are leasing contracts different, Don?
No.
Yeah.
No, we can still do broker to broker on leases and commercial.
So meaning they're the same as they used to be. The only thing that's changed is the residential listings, right?
Yeah. So remember, there were 2 documents that would create broker to broker compensation. There's the TXR 2002 that's used for leases, broker to broker on leases, and then the 2402, which really could have been used for either one. And now it all makes sense to me, because I kept thinking, why in the world do we have 2 documents that create the same thing? Because now, since the 2402 can do either sales or leases, why do we need the 2002? Why do we need the 2002? Now it has become clear why, because the 2402 evidently was always going to be a temporary document.
Yeah, designed to go away, apparently.
Yeah,
So, yeah.
And it was designed to do a job for a while and then go away, leaving the 2002 still in place to create broker-to-broker compensation on leases. Now it all makes sense.
Yes.
And I'm sure everybody's saying, yeah, I'm glad it makes sense to you.
Yeah, it's clear as mud.
Right? All right. Are we ready to move on, or do we still have questions? I knew that we would need to take some time to linger here for a while.
Looks like we're good.
All right. Good news is that's really just about the end of the major changes to the contract. So the rest of it, when you look through, there's not really anything marked until we get to format. Now, they've made some format changes to the contract itself, to the document itself. Prorations, all the same. Casualty loss, all the same. default, mediation, attorney's fees, escrow, all that stuff's the same. We don't have any changes at all until we get to section 20. Excuse me. And so section 20 used to be talk about foreign seller requirements. Now it's governmental requirements. And they added in a new section that talks about seller and buyer shall promptly execute, deliver any statements, documents, and information requested by the escrow agent, of course, title company, required by governmental reporting requirements, for example, reporting to the U.S. Treasury or its bureaus. So we'll hit that in just a second. Section A, what the contract says and what actually ends up taking place is kind of two different things. However, the ultimate responsibility to collect this money from a seller who is considered a foreign seller is ultimately the responsibility of the buyer and the buyer's agent. And so what it says here in the contract follows what the law says, but we rely on the title company to actually collect that money. So let's just look at it. If seller is a foreign person as defined by the Internal Revenue Code and its regulations, or if the seller fails to deliver an affidavit or a certificate of non-foreign status to the buyer that seller is not a foreign person, then buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable tax law and deliver the same to the Internal Revenue Service together with the appropriate tax forms. Internal Revenue Service regulations require filing written reports if currency in excess of specified amounts is received in the transaction, which of course is $10,000. So the document says if our seller is a foreign person, then the buyer is required to collect a certain amount of money and hold that money or send that money to the IRS. The reality is the title company does it. And so when the title company does it, there is a law called FIRPTA, F-I-R-P-T-A, FIRPTA, that requires this collection of money. Now, the maximum amount to be collected is 15% of the sales price. So we're talking about a substantial amount of money here.
Mhm.
And so normally what ends up happening is that that's what's collected. The full 15% is collected because we don't know for sure what the IRS wants. And so the maximum amount is collected, sent to the IRS. The IRS does whatever they're going to do with it, and then whatever's left over will be sent back to the seller. This says that it's the buyer's responsibility. So if, for since if the maximum were not collected,
Mhm.
if the title company, let's say, collected 10%, and this happened to be a transaction that required the whole 15%, that 5% shortage falls on guess who? Buyer and
Buyer.
buyer's agent.
Yep.
And so the law says that it's the buyer's responsibility to collect this. Title company will do it for us. Most of the time, they're going to collect the full maximum amount of 15% of the sales price, send that to the IRS, let the IRS take whatever chunk they're going to take, and then send the rest back to the seller. So just to clarify all of that.
I'll make it even worse for you guys. It varies. This is a federal requirement, varies by escrow and by state. Some states require a CPA to prepare the documents before escrow will even touch it. Escrow will not do the math and collect it in some states. Washington, California, some of those like that, because of the risk involved in this. And they also have the exemption if the buyer will attest that they're going to live in the home as their personal residence, that tax reduction or could be less, down 10%, as Don was saying. But it is the buyer's responsibility. So find out from title, is the seller a foreign investor, right? By the way the IRS declares it. And if they are, make sure that an appropriate amount of money is withheld. Otherwise, the buyer will be responsible for it. Yep. Because if the seller leaves the country, IRS is not going to go chase them down. IRS is going to chase you down, the buyer.
Isn't that crazy?
Yeah, it is crazy.
Yeah, once again, I had a closing not too long ago where the seller is a foreigner person, and we went to a third-party company that insured that part for like a $15,000, $16,000. The seller can get all their money. just to let you know, you can always ask the title company to refer you to one of those third-party companies.
Good point. Thank you, Samantha. Yep. So B, what I highlighted, this is added in because there have been times where documents have been asked for or information has been sent out and the seller didn't fill it out. And so now this makes them in breach of contract. By putting it in here, seller and buyer shall promptly execute and deliver any statements, documents, and information requested by the escrow agent. If the title company sends out an informational sheet asking for this information and it does not get returned, then either buyer or seller is in breach of contract. So make sure that if your buyer gets that, or even a seller, either one, that they fill that information out and send it back to the title company, because if they don't, they could be in breach of contract. Section 21, notices. Only thing that I highlighted there was another way that notices can be delivered, which is by overnight courier. The rest of those were all the same. The only other change really here is in format. They really, really do not want an agent to just put their own information. They want the client's information there. And I know a lot of times agents will just put their information there because they're trying to control the flow of the information, and they're also trying to protect identity for their client. They don't want to put the phone number, they don't want to put an email address. I know, I get it, I understand it. However, you need to. That if they don't want to put their phone number, fine, but at least put an email address, because a copy of this contract can go to a lot of different places. It can go to a lender, it could go to an appraiser, it could go to an insurance company, will go to the title company. It's going to go to a lot of different places, and any of those entities may need to contact the client for something. They need to have the ability to do it, because if you just put your contact information there and something is sent to you and it happens to be time sensitive and you don't get it to the party in the amount of time it needs to get there, then we have an issue. And so there is potential liability there. There's potential liability for you as an agent. There's potential liability for the brokerage. There's potential liability for the broker. You don't want to put yourself or your broker or your brokerage at risk. So make sure you put contact information there as well as yours. You can put your information there too. Just don't put it there only. Make sure you put your client's information there. Section 22, which now takes up an entire page of the contract, is one of the things that made our contract go from 11 pages to 12 pages. It is the addenda that may be attached to the contract. If you remember the old contract, we had two different columns of potential addenda. Here it is a full page. There's a full page of addenda that could be attached to the contract, and they just break it out in different sections based on what type of addendum is it. Is it a financial addendum? Is it one of those leases? An additional test or report having to do with condition of property? The statutory disclosures and notices. And here now is where we see the water district information. So if there is a MUD, what used to be in section 6E, number 12, title notices, is now here. I mentioned before that it was not really removed, it was just moved. So here it is here. So whatever water district the property happens to be in needs to be identified here. MUD number 123 or whatever it is needs to go there. And then other documents that they're adding in there, they're saying that if you don't add these documents in, that it could create an ability for the buyer to terminate the contract. If these were things that were required to be in there and they weren't, then it could give the buyer the right to terminate. Those the statutory documents, sorry. The ones up above, these here. That if these are required to be delivered as part of the transaction and they're not, then it gives the buyer potentially the right to walk away. Rest of the contract, all the same. Just things got moved up a different page. What used to be page 9, which used to have the effective date and the signatures, is now page 10. What used to be page 10 and is now page 11, which is the brokerage information where we used to put our information, format change. So where it used to be, the listing side used to be on the right. If it was intermediary, then it also was on the right. If you were on the buyer side, you were on the left. Now, instead of it being in columns side by side, it is now stacked. So if we are representing the seller, then you fill out this top information here. And of course, if you are a HomeSmart agent, make sure you know licensed supervisor of associate is always Mr. McClendon, is always Marty McClendon. It is always him, and always his license number of 804082, 804082. My name should never show up here, ever. Same thing if we're on the buyer side, that goes in the middle section. Same thing applies, license supervisor, still always Marty, always his license number. If this is intermediary, whether it be intermediary with appointments or intermediary without appointments, either one, then we'd fill out the bottom section where we put the information for on the listing side and the information on the purchase side. Again, licensed supervisor, still always Marty. And that's it. Then the last page, which is now page 12, is still the receipt page. All that information is still exactly the same. So that gets us through the sales contract. I know there's a lot to it. The only other thing that I didn't mention before that I'm going to want to mention now is back up here. This groundwater and surface water disclosure, you will not find that in the condominium contract, because obviously when you buy a condominium, it does not include the sale of land. If there's no land, there's no place for surface water or groundwater. So you will not find this in the residential condominium contract. So that's really the only other thing that I meant to mention and didn't. So, all right. Before we go to the listing agreement, any questions, anything that we need to cover before we move on?
Yes, hello, Don. While we were in the in session, we had a text from just for broker support, and they were asking, and it was coincidental because it's how can we find the proper amount to place under seller contribution to closing cost. So I know there's different ways to find out. One of them is to just primarily be transparent and ask the lender, well, how much they're allotted to ask for from the seller, and if it's 1%, 2%, 3% max or so, and there you go, you have a number there for that line, and then of course if it's not needed, it goes back to the seller. Correct?
Yep, absolutely. Somebody should have been tuned into this class.
Yes.
So of course, yeah, we do know that there are maximum limits. So if this is a conventional loan and the buyer's putting less than 10% down, then the maximum that the seller could contribute, if there's enough charges to take it all up, 3% of the sales price. On a conventional loan, if the down payment is between 10 and 25% down, then it goes up to 6% of the sales price. And if the down payment's greater than 25%, then the maximum amount is 9% of the sales price. But you still have to have enough charges to actually use all that up. So FHA, 6% of the sales price, VA, 4% of the sales price. If your buyer is an investor, then 2%. 2% is going to be the max. 2% of the sales price is the maximum. So there are limitations, definitely limitations. You don't want to throw out numbers there that just make absolutely no sense at all.
And obviously with the sales price of property makes a huge difference. $200,000 property, 6% comes pretty fast.
Exactly. Right. Exactly.
A $700,000 property, you can spend a whole lot of money buying down the rate. So.
Yeah, right. Yes, exactly. Yep.
Thank you.
Who do I call to help in filling the contract out because I'm filling it out for the first time? Yep. You would call the broker line.
That's the broker line.
Yep.
Or maybe mentoring might not be a bad idea. But yeah.
And mentoring, that'd be Don.
All right. Any other questions? All right. There we
I'm
go.
actually waiting for, this is Hengame, waiting for sending me those paper to sign. I think to have a mentoring with Raul.
Gosh, that was sent back
I
on.
didn't see anything to sign for it.
Okay. Well, I'm going to have to take a look because that was sent before I went on vacation.
Yep. We'll get it figured out for you. And then Angelica's asking for a cost for private mentoring, I'm assuming. So reach out to Don. We'll talk to you about the whole program, Angelica. Yep.
All right. Can you see the listing agreement okay?
Thank you. If you send it, I haven't seen it, but I'm going to double check again.
I wonder if it went to spam. I'll check it. I'll check and see.
Thank you.
You're welcome. No problem. You got a good mentor there too.
Yes, Mr.
We're glad to
Raul.
be your mentor, yes.
Yep.
Yes, thank you so much.
You're welcome.
You're welcome.
All right.
Thank you. Thank you.
So on to the listing agreement. And so now, of course, with the sales contract like it is, and the changes that have been made, it created a change to listing agreement and even changes to the buyer rep, but really the major changes to the listing agreement. So there's really one big change. When you look at the listing agreement, all still pretty much the same. Now remember, listing agreement is not a TREC promulgated form. It's not promulgated by the Real Estate Commission. It only comes from the Texas Association of Realtors. So there is no TREC number or letter for this form. It's only a TXR form. And so, like we said before, the Texas Association of Realtors does not go and change their form numbers. They change the version of the form, but the form number remains the same. The Real Estate Commission changes form numbers, that the old 20-18 is now retired and the 20-19 is one you're required to use. So the reason why probably would make a lot of sense, that when the Real Estate Commission creates a new form, the old form is no longer available for use. If you use the old promulgated form, you're practicing law. That is considered the unauthorized practice of law. These forms are not promulgated by the commission. And so if you use an old form, it's not acceptable. They have to be put onto the new form because those have the changes. It's just that it's not considered the unauthorized practice of law. It's not correct, but it won't get you in as much trouble. The only thing it'll get you is a requirement from compliance to put it on the right form. You do have to have it on the right form because the requirement is whatever changes have taken place are not reflected in the old form, but they are in the new form. But that's why they don't change the form number on the Association of Realtor forms. So,
Hey, Don, two things. One on that is obviously we hear promulgated. When we think about TREC forms, they are forms created by the state to comply with state law. Texas Realtor forms do the same thing, but they're forms that we can use through our association with the association. Whereas TREC forms are forms we have to use as licensed agents, or their counterpart that meets the same requirements. So these are forms that we require, but it's one of those things where we get the option of using these forms if we choose to as realtors. Second thing, Don, Laura asked for a little 5-minute potty break. So yeah.
We can do that.
Okay.
What do you want me to do with the recording?
Just pause it.
How do I pause it?
I'll do it. So here up top, it says record. Just right click on it.
Recording. Pause recording. All right, now we move to the listing agreement. And again, the major change has to do with compensation. So look at the First page, the only other change that we see here on the first page is to bring it in, being consistent with the sales contract, where the sales contract talked about that the sale would include generators. They added generators in here as well. So the same list that you see on the sales contract, you should also find on the listing agreement. Section 5 is where we see the biggest difference. Broker compensation. There is no more broker-to-broker compensation being offered. So we only talk about what we are going to charge the seller for representing the seller. And so, of course, the language that's there is that information is required by the NAR lawsuit that says compensation paid to brokers or the sharing of compensation between brokers not set by law, fixed, controlled, recommended, or any of that. Compensation paid to brokers fully negotiable. Each broker independently determines their fees. So, of course, on the listing side, we determine the fees that we are going to charge the seller. On the buyer representation side, we determine the fees that the buyer is going to pay the buyer's agent. And so 3 different boxes here. So in most cases, it says click one box only. But in this case, the opportunity for compensation could be more than just one thing. So let's look at what it says. When earned and payable, the seller will pay the broker, select all that apply, insert the amount to be paid to the broker only for services performed under this agreement. So this means that representing the seller, we are going to receive whatever we have in these blanks. So if we check the first box, then we have an option. We can either charge them a certain percentage of the sales price, or we can charge them a flat fee, one or the other. That says or. You see or is underlined. So they don't want you to do both. They don't want you to do 3% of the sales price and a flat fee of $550 like for a transaction fee or something like that. That's not what they're after here. This is an either or. So 3% of the sales price or $10,000, whatever you're going to charge. Then it says, okay, we have seen a lot of situations now where buyers are coming to us unrepresented. And so if the buyer's coming to us unrepresented, we know that that creates an additional responsibility. So if it's going to create an additional responsibility on us, there's an opportunity to charge more money for working with an unrepresented buyer. So I can charge you my regular 3% seller. That's what I'm going to charge you to represent you. But that's just you. That's taking care of you. Now, if the buyer comes that wants to buy this property, if they are unrepresented, then that means it's going to create more work for me. And so in that event, I'm going to charge you an additional money to do that work that I'm going to have to do for this unrepresented buyer. And again, you have 2 different ways that you can charge that. An extra percent of the sales price or some additional flat fee. I'm going to charge you 3% of the sales price unless I have to do both sides. And if I have to take care of an unrepresented buyer, then I'm going to charge you another 1.5% or whatever it is. So you can do both of those.
Still, we're not responsible. I mean, ethical, yes, we will do our best. Well, we're not responsible for them, correct? Even after we get paid for it.
Yes, even though
Okay.
you're getting paid for it. Payment, so this is what the License Act says. Payment of a commission does not establish representation. Representation is established by a written document. In that case, it'd be the buyer's rep. Since they're unrepresented, there is no buyer rep, there is no representation. So even though, yeah, you're receiving a fee for it, it did not create representation. It's a good question though, because a lot of times we think that if I'm being paid to do this, then there must be some agency that goes along with it or some representation that goes along with it, but there is not.
Donald, they would still have to sign the form stating that they're being unrepresented, right?
Yes,
like
ma'am.
investors? Okay,
TXR 1417 representation disclosure. Yes.
good. I knew you knew the number. I just didn't know it.
So yeah, TXR 1417, the representation disclosure has to be signed by the party who is unrepresented.
Represented.
Sometimes we've had the representation disclosure come in that's signed by our client. Our client knows that we're representing them. It's not them that we need to notify. It's the other side who's not being represented that needs to acknowledge that they are not being represented. So yeah,
Usually the investors.
Yeah.
a lot of times, yeah.
Yes.
Yeah.
We've seen that form signed by both parties too, and they're like, and both names on there, like, wait a minute, it's not that what that's for.
Yeah, we didn't need it. It's overkill. We'll take it. Right? We won't make them go back and redo that.
What do you mean? We can help seller and buyer and not represent neither one of them still get paid, right?
No, we
No.
weren't. No,
Oh,
no, we were saying that that form is only supposed to be signed by the side who's not being represented, but sometimes the agent will go ahead and get both parties to sign it, stating that the seller is being represented or the buyer is being represented. It's only the side who's not represented that needs to sign it, but sometimes the agent goes ahead and gets both sides to sign. It's overkill, but it's better than no signatures, that's for sure.
thank you.
You're welcome. Third line. So we kind of wondered, we were kind of afraid that what would happen here is that agents would try to go and try to start creating broker to broker compensation again. That they would go up here and they'd say, I'm going to charge 6% of the sales price. And then down here, I'm going to check the box and say, and I'm going to share 3% with the buyer's agent. That's not going to work because there is no document to create that anymore. You may create it here, but there's no way to create it for the buyer's agent. There's no place, there's no 2402 anymore. So that is not what that's for. If we see that go in there, it's going to be kicked out because broker to broker compensation does not exist. Not anymore. Not unless it's a lease transaction or commercial transaction. So what can we use this line for? So we kind of wondered the same thing for a while, and one of our brilliant agents came up with it. And you could use this if you are representing both sides. That if you are representing, if you're doing intermediary and you want the seller to pay both sides, you could go ahead and use it for that purpose. So there is a way, there is a reason for it. Otherwise, we couldn't figure out if it's not going to be a percentage of the sales price or if it's going to be an unrepresented buyer, what are the other options? And it could be if it were a net listing where maybe the commission's going to be based on the net rather than the sales price. That's the only other thing I could think of. But most likely, you're not going to use this.
That's what I was thinking. Because we're not allowed to do intermediary, right? Not anymore.
You can do intermediary.
We still do?
Yeah, we can still
Represent the seller and the buyer?
Well, again, the phrasing there, you
it's
don't.
Not our favorite. It's not our favorite thing.
There is a strict instructions if you choose to do intermediary without appointments. Now that said, all HomeSmart to HomeSmart transactions are intermediary because the broker's intermediary. However, when you say phrasing, you don't represent both sides. What you end up doing is modifying both of your agreements to be a intermediary, a neutral third party where you can't give advice to either side. So you basically have taken a pre-existing agreement where you have a fiduciary duty to your client and saying, I no longer will uphold that agreement. I'm going to modify it to facilitate this transaction to no one's benefit. So even though you can, we don't recommend. Right, Don?
Yes. Absolutely.
Yeah, because I believe by then we were representing the seller, but okay.
Yeah, buyer's unrepresented, then that's not intermediary because we don't represent both sides. All right, this section down here is not new, but it gets missed a lot, but it's now becoming a little more important. Because since there is no broker to broker compensation anymore, then the question may become, will the seller pay the buyer's agent? And so if the seller agrees to that, if the seller says, okay, yeah, I would consider paying buyer agent compensation. I would consider doing that. Then you would probably want to fill in this: seller does authorize the broker to disclose to other brokers and prospective buyers that the seller will consider contributing an amount towards buyer expenses such as buyer broker fees or other expenses payable by the buyer under the sales contract. So if the seller says, yeah, tell them I'd consider it, and then you don't have to commit to anything here. It's just whether or not they would consider it. And so if you check this box here and put does, then you got to drop down here and you're going to need to do this form here, the TXR 1412. That is where you get the language that the seller authorizes you to use to inform the other side as to whether or not they would consider an offer that would request a concession to the buyer in some way, either by paying buyer agent compensation or something like that. If you put does not, if you mark does not, then that saves you from having to do this form. But it also creates a situation that when the buyer agent calls to ask you whether or not the seller would consider paying a buyer agent, is there any buyer agent compensation, or would the seller look at paying buyer closing costs, your answer has to be, seller's not giving me permission to talk about that, or the seller has not indicated that they are willing to do that, or any of that, because they haven't given you permission to say that. So be careful with the way you fill this out.
So Dawn, are you saying that, because the way I read that was that if it's just a general, yes, they'll consider it, you don't have to do the extra form, but you're saying that if you're checking yes, that you should still do the TXR 1412. I always thought that Houston TX 1412 was being when they were specific about what they would contribute.
It's one of the options. So in the 1412, and I don't have a 1412 pulled up, but there are two options. In set number one, or letter A, whichever way they've got them situated. If it's the first one, then that's a specific amount where the seller says, yes, I would pay up to this amount in there. The second one is where you would use more general language. That's like the language where it'd say, seller will consider all offers, or bring all offers, or seller motivated to sell, or any of that. And you can put in there that the seller would consider offers that include a concession to the buyer. So the first option is, yeah, where you're going to get specific. Second option is where you're going to get vague. And so, but either way, it's language that the seller has to authorize you to use, because if you were just to say yes, then you're saying you're offering the possibility of the seller receiving less than what they would have netted.
You could be harming your sellers. Yeah, you could be harming your seller's ability to negotiate if you give up something they didn't tell you they can give up. But I've seen it also in that form, Don, where it says seller would be entertained paying a buyer broker compensation or whatever with an acceptable offer, right? General statements, but so. Yep.
And we can still add that in the MLS and agent remarks?
No.
For the, not anymore.
No.
Only if they call us and ask us or send us an email.
Okay. I have a question, Don. So if you go to a listing and you talk to the seller right then when he's getting his interview with you or whatever, and ask him, would you consider paying compensation or to the other agent? If you disclose that at one time when you go to the closing, when you go to your listing appointment, and he says, absolutely, then you don't have to do none of this, right? You can just get the 1412 and have him sign it.
1412. So yeah. I think if I was at a listing appointment, I think my recommendation to a seller would be not to get not to commit to anything. Just say that you would consider it, because until the offer comes in, you really don't know whether you really are willing to do it or not. And that's the beauty of this now, is that you're not committing the seller to anything, where we used to. You know, that if we did broker to broker compensation, that really was supposed to be committing the seller to paying whatever that amount was. And then we were supposed to negotiate the offer around the commission. That's what was supposed to happen. But what would happen instead is we would call the listing agent and say, is there buyer agent compensation? And they'd say, it depends. It depends on what the offer is. No, it really didn't depend on what the offer was. If you had a listing agreement that committed you to sharing 3%, that was committed. Here, there's nothing committed. So, Marie, I think that, you know, for me, if I was doing my listing appointment, my recommendation to the seller would be, let's just tell them that you would consider it, because that way you're showing at least that you're reasonable. You know, that you're realistic, that you're a rational seller here. You're not just drawing a line in the sand and saying, I dare you to even try to cross this. That you're saying that, you know, depending on the rest of the offer, then yeah, we'll consider anything, because yeah, we care what the property sells for, but what do we really care about? If I'm a seller, it's how much money am I going to walk away with? How much money's in my pocket when we're done with this thing?
Right.
And once that can be reflected in the TXR 1412, correct?
Absolutely.
Well, another question is that if you prepare, and I heard this from another agent with another company, that if you prepare them prior to the listing or when you go to your interview, and then you can pay the selling agent maybe 2%, and she can get 1% from the buyer's agent. Is that okay?
I think we may have, I don't know if we mentioned that today or not. I know I talked to somebody about it earlier today and said that very same thing. It's like, you know, if you used to commit to 3% and you were committed to that, you never know. This is an opportunity potentially for the seller to pay less than they would have had to pay, because who knows, the offer that comes in may only be asking for 2%. You never know.
That is correct.
Yeah.
That is
Yeah, I agree with you. Absolutely.
okay.
Yep. All right. Rest of the agreement, pretty much the same. Not really any changes there. It's really just it really was just the compensation that was different. The rest of it, all pretty much the same. A couple of things I will point out that I know we run into quite a bit. Section 12 of the listing agreement, the letters E, F, I, and K are left blank. Do not leave them blank. I know a lot of times we think that leaving it blank means they don't apply, but that's not true. Leaving it blank means we left it blank. It means that we didn't answer the questions. These are questions that really need to be answered, and you cannot assume. Don't assume. You know, I've always heard the old saying of if you assume, what that does. But anyway, especially E and F. Seller is current, not delinquent on all loans and all other financial obligations related to the property, including but not limited to mortgages, home equity loans, home improvement loans, homeowner association fees, etc., except we need to get the seller on record saying that there's nothing else here, that there's nothing else that would keep this property from being sellable, because that's basically what we're asking. Is there any situation that exists that could create a situation where the property cannot close? And if that's the case, we need to be aware, because if that's going to happen, then first of all, I don't think I want the listing. Second of all, it would have to be something that would have to be disclosed to a potential buyer that, hey, you're taking a risk here, that you're taking a risk because there are liens on this property. And if those liens cannot be corrected or cannot be released, you're not going to be able to buy. And it really became an issue because we had an issue not here, but at another company that I worked at. We had an issue where those questions were not answered. And it turned out that the property could not close because there was an IRS lien on the property and it could not close. Well, the buyer wanted to be reimbursed, and pretty much rightfully so. It's like nobody told me that there was this $75,000 lien on this property, that the assumption by the seller was the IRS would release it, that they're going to release it because they're going to be able to walk away with $40,000. They would rather have $40,000 than nothing. And so they're going to release this deal. They're going to take my $40,000. That'll be the end of it. Didn't happen. IRS said no. Said, no, we're not going to release this property. We want it all. We want more than that. And so it did not close. When it didn't close, buyer came back. Buyer wanted to be reimbursed for everything that they had paid. Plus, on top of that, it was treble damages because it was known there was things that were not disclosed. So it became an issue with the seller. Well, once it became an issue with the seller, where'd they go and look? Listing agreement. So they went to see whether or not the agent had done their job and even asked the questions, and they were blank. They were left blank. And so the agent was held just as accountable as the seller, because if the agent had asked the question, at least they would have been protected, because if the answer was none here or NA, then the assumption hopefully is that they asked the seller and the seller lied to them. So the agent would be in the clear too. What are you responsible for? What you know or what you should have known? Well, if I didn't even ask the question, that's going to fall under I should have known. And so in this case, it ended up agent and seller had to split the cost of reimbursing the buyer. So that's why we asked the question. Because
does that include mechanic liens also?
Any lien.
Any. Okay.
Any lien.
That's
One more thing on this, Don, for everybody here too. This is the number of lawsuits we've seen over the last 30 years, in Don's case, 40 years. Oftentimes it comes down to where an agent didn't complete the contract. He left the blank somewhere, it wasn't completed, where the contract became unenforceable, and the agent should have known better. So they're looking for someone to sue. The agent is an easy one to sue. So make sure, we always talk about, make sure they're complete. Make sure the seller fills out the seller's closure complete. Make sure the contract, there's no blank spots. It's very important, so you don't get dragged into a lawsuit.
One thing about the taxes, go ahead. I mean, the one thing about the taxes is sometimes sellers don't pay because they assume we're going to pay after we close, and they're supposed to pay it already, but it's not, they don't have a lien on the property yet.
Yeah.
So how we can represent that?
You ask the question, and if they say no, then no. And so you're right. I mean, it does ask about encumbrances. And if there is money owed for taxes, whether it's a lien or not, that's an encumbrance. So they should be answering yes, that there are back taxes that are owed. But I get where you're coming from, because again, not delinquent on all loans and all other financial obligations related to the property, that it would fall under that. So they should be disclosing that.
Okay, fair enough. Thank you.
Sure.
And it's always good to remind your buyer to check with the county assessor to see if there are any taxes owed before you close.
And yeah, that's one thing about Texas, that if somebody's behind on their taxes, you can go to the county website, the county tax website, and you can see if they're behind. So.
And also too, the other thing about that, if you disclose that and you're all up front, then title can make sure, especially if it's something that they're pretty sure will get covered by the monies that the seller's going to be receiving from the buyer, that all that gets paid at closing, then it can all go forward.
Sure.
It's a
yeah,
matter
exactly.
of
Yeah.
sure
If I have a $10,000 lien and $75,000 in equity, then
right.
Yeah.
I'm going to pay for that, but I need you to know this so it's not a surprise. It doesn't slow down closing and all of that. But just so everybody knows, just because you have a lien doesn't mean you can't close.
Oh no, yeah, you're right. Yeah, I mean, there's all kinds of liens on property that can be taken care of at closing. Yeah.
An important one there, Don, also, I know we're not covering, but it's on the listing agreement for lease or for leasing, where also these questions pop up. And it's so important because then if they're by any chance behind, then they're counting on that maybe lease or actually lease amount payment to cover that mortgage. So it's always good to be aware if they're behind or not, so they can catch up and not put in any I would say the word anxiety or I would say more like a problem to the tenant, right? Just staying there without a mortgage being paid. So it's always good to have those disclosed up front.
That is such a great point because a lot of times the landlord may feel like, well, it's none of the tenant's business. It's not going to matter. I'm not selling them the property, so it's really none of their business. This has nothing to do with ownership. Well, if the property ends up getting foreclosed on and the tenant gets booted out because the property's been foreclosed on, then that tenant is going to probably be coming back after that landlord and agent if they didn't answer the question for not disclosing to them that they were leasing a property where there is a danger that they were going to be thrown out. So it's a great point. It's a great point, Raul. Thank you. All right. The only other addition here is, like I said before, when we looked at the sales contract and we talked about the seller disclosure about groundwater and surface water rights, this is a listing document now. This is just like the seller disclosure property condition, except it has to do with water. And so if it's a form that's going to need to be filled out, it needs to be filled out at the time of listing. And that way you've got it in your MLS, you've got it as an attachment in MLS, and then it can be downloaded and be included in the sales contract itself.
And I believe, I'm sorry to interrupt, but the thing is, when you have a riparian rights, for some reason you get another tax bill separate than the regular tax bill. Buyers need to be aware of that.
That's true. Yep. And don't miss this one either because it's kind of buried and it's easy to miss where we're asking the seller whether or not they are a foreign person. And so that is part of the listing agreement. Also, we need to ask that question because it turns out later on that we didn't even ask it. Then if there's any issue, we could end up responsible too.
Okay, and on that note too, we're asking them if they are or are they not. They are going to answer that. And if they turn to you and say, well, am I or am I not? Send them to the IRS website so they can make a determination. You're not the one that's saying, no, you're not, or yes, you are.
Yeah. No, and didn't you mention that before, Marty, that here in Texas that they're trying to make this our responsibility, but at least for
Yep.
now it's not?
Yep. Yep. Right now it's in discussion between the Texas realtors and attorneys and the Attorney General's office. Yep. Crazy.
Yeah, just one more thing. Yeah, just one more thing. All right, that's really it for the listing agreement. And that, I mean, the major change is that compensation. No longer do we discuss agent to agent compensation or broker to broker compensation. It just doesn't exist. Our conversation with the seller, this is how much I'm going to charge you for representing you. Be aware that is very possible that when the sales contract comes in, there it may include the request for you to pay a buyer agent. Well, am I going to have to do that? We're not committing to anything at this point. When the offer comes in, we'll look and see if it's something that you can do. We'll do an estimated net proceeds based on the way the contract is written. You can make that decision at that point in time. But can I pay some of it, not all of it? Absolutely. It is all negotiable. It's entirely up to you. It's really a great amount of freedom if you think about it. I mean, it really is like you don't have to pay anything. But be aware that depending on market conditions, that if you don't agree to pay something to a buyer's agent, there may be another seller down the street who may be willing to do that. That'll just have to be a decision that you make as a seller when the opportunity comes up. So, all right. The last document that we are going to look at is the buyer representation agreement. And there are actually more changes to the buyer rep than there were to the listing agreement. It's just that the one or two for the listing agreement is a lot more major. All right. Because they already had made the changes to the buyer representation agreement regarding compensation, where we only negotiate how much the buyer is supposed to be paying the buyer's agent, then most of the changes really are centered around other things. So the very first change or very first addition really is more of a clarification than anything, has to do with section number 3 definitions when they talk about market area. And so it used to just say means that area in the state of Texas specified below, insert property address, subdivision, etc. But now they added in this bolded part. This section should not be left blank. Leaving it blank is just like leaving the dates blank or anything else. This is supposed to be a clearly defined area inside the state of Texas where you are willing to represent this buyer. And so it really, since it needs to be clearly defined, it means you have to be able to tell without hesitation or without interpretation, am I in my market area? Am I in the market area or not? And so putting in things that would have like a directional attached to it. Northwest Harris County. Where does that begin and where does that end? And so you have to have it, like I said, clearly defined. I like to use counties. And for me, that way I know you're either in a county or you're not. But it can be anything. It could be a zip code. It could be inside a city. If you say city of Houston, I think even that opens it up for interpretation. Are we talking about inside the city limits of Houston? Are we talking about inside of a Houston mailing address? Because there are parts of Houston that are mailing addresses that are not inside the city limits. So it really is supposed to be clearly defined. Just don't leave it blank. Because if you leave it blank, then there could be a question where a buyer could come back and say, well, I don't think they were really supposed to be representing me in that area. I didn't agree to that. This is where you're allowed to work. And so if you don't put anything there, you could interpret that to mean you're not allowed to represent them anywhere. Because
Can we add 2 counties?
So
Or 3?
yeah, you can put
Okay.
county. And so I have always used, and I've always shared that I've always used Harris and the adjacent counties. And so that would be Harris in any county that touches Harris County. And so that would be Harris or Montgomery, Waller, Fort Bend, Brazoria, Galveston, Chambers, Liberty. So, I mean, that's every county that touches Harris County. So, you know, it's just whatever market area you want to represent this person in. And you really should not be putting in state of Texas either, by the way.
Don,
Yeah.
you could also put, like, say the property is in Brazoria County, and then you're going to close in Harris County. So you have to put both counties. You can do that, right?
So it's where the property's located. You can close it anywhere, but it's where the property's located. So, I mean, if you think there's a chance that maybe Brazoria County's not going to cut it and we're going to end up in Pearland, you know, where we're almost in Harris County or maybe barely in Harris County, you'd want to go ahead and include both. But it's really where the property's going to be located. It's not where the closing's going to take place.
Yeah, I think what she means is on one part of the contract said where you will get paid.
That's
That's
Harris
what she
County.
means.
That's
Yeah.
where our office is. Yeah.
Oh, yeah. So you're right. Yes. Thanks. Yeah. I'm sorry. I didn't misunderstood, but you're right that, yeah, doesn't matter where the property is. In our documents, we always put Harris County because that's where payment is made. And that's what they're really asking in that section. They're not asking where the property is or asking where is payment going to be made. It's going to be made to the main office in Harris County.
So, Don, you have a buyer moving from out of state into Texas. They don't know where they want to live yet. and they want to look at San Antonio, Austin, Dallas, and Houston. What would you say?
Road trip, no. So the Texas Real Estate Commission has this little thing they call competency. And competency has to do with two things: geographic area and property type. And so the Texas Real Estate Commission says that as an agent, you should not be doing a real estate transaction in a geographic area where you are not familiar with the market. And it also says that you should not be doing a real estate transaction when you're not familiar with the property type, that you are to be mentored or have, how we describe it? Enhanced supervision. Is that how it is?
Yes,
Marty?
enhanced supervision. Yep.
That you have to have enhanced supervision on your first three transactions when you're doing a type of transaction that you're not familiar with the property type or the geographic location. And so you would need to pull somebody else in, or probably the better idea is refer them out to the areas that you're not familiar with. Even though I know we hate leaving money on the table, but I would rather leave money on the table here than leave money on the table at the courthouse.
Excuse me, but on the past, we pay a flat fee to another agent from a different area. We were not familiar, and the agent kind of helped us up a little bit, and we just pay him a flat fee, so we don't have to let that client go.
If you don't have to let the client go necessarily if the amount of assistance they are going to give you would amount to enhanced supervision, where supervision, of course, doesn't mean here, you go ahead and go do it and just get with me once in a while. Supervision is going to mean I need to watch over what you're doing. So,
Yeah.
it depends on whether or not that's the level of what they're doing.
And that can be applied, like if you've never done commercial or rural areas or ranch, if you're not familiar with it, just find somebody, or maybe you guys can direct us to somebody that will help us for a flat fee.
So yeah, depending on where it is, we have agents who are kind of scattered all over the place, and so it's really potentially possible that we could find somebody who could do that enhanced supervision in those areas. But if not, then referring it out would be the best option. I mean, we have to look at not what's best for us, what's best for our client. Is it really best for our client for us to do a transaction in San Antonio where I know I'm going to have to make several trips back and forth? What happens when that buyer wants to get inside the property to measure for curtains? Am I going to want to drive all the way from Houston to San Antonio so they can measure a window?
And I guarantee you, when you don't, that buyer will be upset with you because you weren't there to serve them. So, yep.
Yeah, I mean, that's true. And it's sometimes it's that simplest thing where you may have done a ton of work, but that's one simple thing that they wanted, that they requested, and you couldn't do, is what sets them off.
Hey, Don, I want to take a second look just before closing tomorrow. Can we come and bring my parents over there? Yeah, drive 4 hours for. Come on.
Yep, absolutely.
Mhm.
All right. So there's that. That's the first one. That's the first part. A clarification in section 6 having to do with open houses, and where they talk about client obligations to us. And so it really tells them that, okay, you can be a client and you can attend an open house without your agent. That's okay, as long as you don't let that conversation get too far, and as long as you make sure that whoever is hosting that open house knows that you are represented. So we'll just look at the whole thing. Client will A, work exclusively through the broker in acquiring a property in the market area and negotiate the acquisition of the property only through the broker. So again, these are client obligations. Work exclusively through the broker, which means I'm not going to be going out and signing another buyer rep or using another agent, and I'm not going to go out and negotiate this thing myself. I'm only going to do it through the broker. B, inform other brokers, sales agents, sellers, and landlords with whom the client may have contact that the broker exclusively represents the client for the purpose of acquiring a property in this market area and refer all such persons to the broker. So if they come across somebody else, then they have to say, hey, I'm committed. I have an agent. This is my agent. They have a responsibility for doing that. If they don't do that, that could end up an issue for them.
Don, at one point from TREC, if I'm not mistaken, it was a big deal that if you didn't show the property to the buyer, you didn't earn the commission. So that is no longer applying.
Yeah, that does not create what we call producing cause or procuring cause. I mean, sorry, that's not procuring cause. Showing the property is not procuring cause. So,
Okay, so what it means,
it works both ways.
Yeah.
Not showing the property does not necessarily mean that you're not procuring cause, and showing the property does not mean you are.
because sometimes buyer likes to wander around and they find listings, especially in open house.
Now, remember, the exception to that is certain builders have a registration policy. If you don't show the property, you don't get the commission.
No, but even just another real estate agent, if the buyer don't mention anything, they take them under their wing and they write an offer. It doesn't never happen to me, but I know that it happens to other agents. And then at one point that was a big deal because I don't know where it came from, but if you didn't show the property, you didn't earn the commission. So once again, that is no longer apply or still going on.
It never really did.
What did that mean? Means no.
That never really was the case. It never was. Only if you were going to say that, the only time that you could have even potentially said that was before the days of buyer representation.
And it happens to be that sometimes buyers go ahead and find another lender in another house and they don't even tell you.
Yeah,
so they're out the hook.
Sometimes they don't. But ever since we've had buyer representation agreements, that the protection is through the agreement, not because I showed you the house. That it used to be when everybody used to represent the seller, that yes, if I'm the one that took you across the threshold, then I was considered procuring cause because I didn't owe you any fiduciary responsibilities anyway. But once buyer representation became a thing, being the one to take them across the threshold does not create agency. It does not create representation. It doesn't create procuring cause.
Yep. Even though many people argue it, they're incorrect. It's a misnomer. I will say this too. One thing that people don't understand about buyer tenant reps. Rochelle's got a buyer tenant rep with Dawn, right? Goes there. Dawn, she's got an agreement. Dawn goes and buys a house that she showed him while he's under her rep. She's still entitled to her compensation. Dawn goes and signs a new buyer rep with Didrion. Then all of a sudden, now Didrion's owed the compensation, and Rochelle's out of the blue because that new buyer rep takes the place of the previous one. So be aware of that. This protects you if your buyer goes around you and buys a property without another agent only.
So if the buyer signs another rep with another agent, you're gone. You're history.
Well, let's say that Rochelle has a buyer rep. Dawn gets to know a new one with the same buyer. Okay. If Dawn's amount he's charging that buyer is the same amount Rochelle is, Rochelle has nowhere she can get it. If for some reason Dawn's was lower, then you could go after the difference in the amount that was owed. But yeah, you're pretty much done. The Realtor Association wants to make sure a broker or a realtor gets paid. They don't care which one. So make sure you're aware of that.
Okay.
Yeah, thanks. Even if you're in that protection period, there's not really much protection at all.
Yep. Good to know.
All right, so here's the part that was added in. Attendance at open houses or property showings with other brokers or sales agents where no advice, opinions, negotiations, or substantive brokerage services are provided does not violate these obligations. So if I'm going to an open house, or if I call the listing agent, and I tell the listing agent that I am represented, but I want to see their listing, and the listing agent says, okay, I'll show it to you, as long as there's nothing as far as advice or opinions or anything like that, anything that would require an agency relationship that takes place, then the buyer hasn't done anything wrong. That's what it's saying, that the buyer can go ahead and look at other properties, They can go to open houses. They could call the listing agent, have the listing agent show them, but they have to inform that listing agent that, hey, I'm represented, but my agent is on vacation, or I can't get a hold of my agent, but I really want to see this property. Will you show it to me? That allows the listing agent to go ahead and show that property to the buyer and not violate that relationship with the buyer's agent, where the buyer has not violated that relationship. They haven't violated the relationship as long as they have informed the listing agent, and the listing agent doesn't do anything to try to steal them away. If the listing agent does something to try to steal them away, then that's going to be an issue.
Builders are the worst with that.
Do what?
The builders, they are really bad about that. You can, the client can tell the builder and they'll try to go behind them. If you sign with me, I can give you a better deal, or
So
yeah,
the builder typically is not an agent.
right.
And so they are not really bound by exactly the same rules that we are. And so it's going to be a little bit different. That builder rep typically is not an agent. And if they were an agent, then they probably have their license inactive, probably because the builder made them do that. So they don't have the same responsibilities. They don't not held to the same level that you and I are. But I get you. You're right. I know they do that a lot, that they will say, hey, if you ditch your agent, then I can get you a better deal. Yeah.
Yeah, and I always give my clients extra cards. So if you go
Mhm.
to any open houses, talk to any other agents, any builders, you just make sure you give them my card. I mean, I make sure I answer my phone. I'm always available, but I always give them extra cards. If they don't want to hear, just give them my card. Just
Yep.
give them my card and my number. They'll call me. And I've, knock on wood, I've been successful with that as well.
Yeah. Yep. Absolutely. Yep. The rest of that, client will inform other brokers, sales agents, sellers, and landlords with whom the client may have contact that the client currently has a representation agreement with the broker. So the responsibility is on the buyer. We need to make sure the buyer understands that. It's like, here's the issue, buyer, that if you don't let people know, then you potentially could end up owing two commissions. You go ahead and you go outside of this agreement, you go do something else, then you could end up owing. You could end up having to pay it yourself.
But in reality, you just mentioned it that if they sign another wrap agreement with the new agent, practically we're gone.
If our agreement is still good, we might have recourse against that buyer if they went ahead and moved on. If our agreement's still good.
It doesn't matter if they sign another agreement with another agent later.
If they sign another agreement with another agent, then they are violating our agreement.
Okay.
Yeah. What you may recoup is different, and you may have to do an arbitration claim against the other agent too. There's different ways to do it, especially if that agent's being aggressive and knowing that they have an agreement with somebody and they're being unethical. Yeah.
Yeah, exactly. They added in a new paragraph just again to make it extremely clear that in this case, in the buyer rep, because we seem to have this issue in the buyer rep, we don't have it in the listing agreement. When the seller signs it, they're fully aware that they are responsible for paying that commission. We still seem to have this issue on the buyer side where it's not being made clear to the buyer that the buyer owes this compensation. And so that's what it's at. Source of compensation: client may seek to obtain payment of the broker's fees specified in paragraph 7A from the seller or the landlord. So it says, okay, that the client may seek to obtain payment. So the buyer may ask the seller, hey, help me out here. Will you go ahead and pay what I have agreed to pay my agent? Broker will assist the client in negotiating any contribution from the seller or the landlord. So, okay, buyer, I'm asking the seller to pick this up for me. Agent, help me with that. Agent, help me get that. Help me negotiate to where I get this compensation off my back and we put it into the responsibility of the seller. But, however, Client remains responsible for payment of the broker's fees specified in paragraph 7A, which will only be reduced by the amount contributed, if any, by the seller or the landlord. So this says that buyer, be aware that ultimately this is your responsibility. You owe this. We'll do what we can to switch it over to the other side. We'll do what we can to transfer it to the other side. But ultimately, this is your charge. And I know we've had so many issues with this, where with agents wanting to try to find some way to skirt this, try to find some way of not having to tell the buyer that this is their responsibility. Put 0 in for now, and I'll go and change it later. You are taking a terrible, horrible risk. You've got 0 here. Seller says, I'm not paying a buyer's agent. 0 there. Congratulations, your career just became a hobby. And so no place for payment. So don't do that.
And no way to collect payment because you got a guaranteed of 0. So
you were paid everything you asked for.
Exactly.
But in leases, does landlord pay for both agents, for both brokers? Or how is it work in leases?
In a lease, they can do that still. In a lease, the landlord can pay enough to pay both sides.
Okay.
Now on this note, though, we've had agents come recently that they're upset, they're incensed because the landlord does not have to pay a tenant broker. They can. There's a big difference. So when a tenant agent doesn't secure their compensation, and then they're shocked that they don't get paid for working with the tenant, it's on them. Yep.
Thank you.
Because those landlords are paying less and less for leases now. I mean, I've seen $200 or $150 and couldn't believe it, but that's all they're willing to pay now.
Yep.
You're
We're
right.
seeing more of that.
Let's not go there.
So we don't have a form to represent just tenants. It's a selling buyers and leasing, and
It's the same form for both. Yep. Buyers or tenants. Yep.
so we still have to like put the numbers there, like half of the rent, whatever it is, 50% of the commission. Okay.
Absolutely.
And we can call listing agent and ask what is the commission rate for the tenant representation.
Yeah.
Okay.
Yes.
I have a question. So what if it's a listing for sell and for lease?
It's really supposed to be two separate listing agreements. There's one for sale, there's one for lease.
Okay.
Yeah, on the lease. Yeah.
Okay.
Hey, who's scribbling on my contract?
That's Laura, looks like. Come on, Laura.
It's the phone. It's not.
We're
I did
teasing
want to
you.
point
We're
out
good.
this about notice regarding bonuses. And so, of course, anytime the compensation is going to change away from what you have put up here, then you have to do that 1505, the TXR 1505, to make it match. And so they're talking specifically about bonuses, which is a good thing because it means you're receiving more than what you had in the buyer rep. So you had whatever you had in the buyer rep. You find out that the house that they're ending up purchasing is also offering a $2,000 bonus. Well, you cannot receive that $2,000 bonus until the buyer approves it. And the buyer has to approve it. And the way you get them to approve it is by doing the amendment to buyer/tenant representation agreement, the TXR 1505. There is a specific place for bonuses, by the way, where you would put in there that you are going to also receive that. But the buyer has to approve it. And I know, again, we've had situations where agents try to skirt this because their fear is that once the buyer finds out that the agent is getting more, that the buyer is going to want a piece of that, or they're going to want all of it.
Right.
Nature of the beast. You're just going to have to deal with that because that's the way it is. You can't skirt it and not ask them for it. If it's not in the buyer rep or in an amendment to the buyer rep, then you're not eligible to receive it.
Oh, wow.
I know.
Wow.
Yeah.
Okay, and that's for new construction homes as well?
Yep.
Yep.
There is.
Yeah.
Yeah, with the new construction homes as well, we'll spell out the BTSA. So your buyer tenant rep needs to be amended to match it. Exactly. Yep.
Look at this statement right here.
Yep.
Broker will disclose the specific amount of any bonus offered to broker. Broker may not receive any bonus unless authorized by client in writing.
Wow. Oh,
I
wow.
wish I hadn't highlighted that one.
Right. Hey, Don, one of the scenarios that we have not seen yet, because we still have a market that's flat or increasing over time. In a market where we have missed appraisals come in low, markets where it's declining. This is going to be interesting because you get let's say a seller's paying compensation for a buyer broker. They're paying buyer's closing costs. Appraisal comes in low. Where are they going to renegotiate, right?
Well,
There
and
you
that's what happened to one of mine right now. The house was listed and the appraisal came in for $21,000 less.
Yep.
So they're like, well, I mean, what's up with your BTSA? And I'm like, I mean, what is up with it? So yeah.
And
Okay.
now it's fully negotiable. Now, obviously, your buyer is still obligated to pay you, so that's going to be less likely that they want to come out of their pocket. So they still
Right.
want it in the deal, but still, yeah, it's changed.
Yep. Yeah. And we may be getting to that point because we've definitely seen a leveling off of prices. And in some places, there have been a decline.
Yeah.
Wow.
Protection period. Here's where we were talking about, and Samantha was talking about, if they go on somewhere else, and we talked about the protection period, where there is a protection period where we can receive, even past the end of the buyer representation agreement, the possibility of still having some protection. But it's exactly like Marty said, that the protection period is just there to protect the industry, not individual agents. Remember this Texas Association of Realtors, and so they only care that somebody gets paid. They don't care if it's you, they don't care if it's me, they don't care who it is. They just want somebody to get paid. So this protection period only applies if a buyer were to go around us and try to go directly to a seller. Because this part here, and this is the part that sometimes makes the protection period one of the most worthless provisions in this document, where it says paragraph 7F, that's this protection period, will not apply if client or a related party is during the protection period bound under a representation agreement with another broker who is a member of the Texas Association of Realtors at the time the acquisition is negotiated, and the other broker is going to be paid a fee for negotiating that transaction. So I can have a 6-month, 180-day protection period. But at the end of this agreement, if the buyer goes and signs a new representation agreement with somebody else, I'm out. There's no protection for me.
Right. You're not gonna go and fight with them, right? Okay.
There's that part about what county, Harris County, whether or not intermediary is. The rest of this document, pretty much the same. No real changes. So that's it. How do we do on time? Oh my gosh, it's 8 o'clock exactly.
Hey, real quick, the 90 days protection plan is when you have the listing and expires, and then like it happens to me, an investor was trying to come around and waited it for my lease to expire, and I had the 90 days protection period. But then at one point, the sellers, they were elderly people, they start like crying and acting all offended, like, you never told us about the 90. I said, yes, I did. I told all my clients about the 90 days. And that was because that it was an investor that came to take a look at the property, and he was waiting for the listing to expire so he can come around and buy the property. And he convinced them that whatever commission they were going to pay for him and for me, he was going to be able to save him that money. And they were pretty bad. I mean, that listing expired and it's a done deal. I don't know what happened to it, but I have 90 days and I let them know. But I didn't want to dig into it anymore because they claim that I didn't tell them, although they sign and the initial every single page, and I'm most likely to explain every single page to my clients. They say, no, you never tell us, we were not aware of that. So, they were playing that game.
A lot of times they'll say all kinds of stuff. We ready
Scary.
to stop recording?
Go ahead and stop recording, or